Welcome to the webinar. My name is Marty Schenkman, and I'm joined by two colleagues, Bob Keebler and Jonathan Blotmacher. And what we're going to try to do in the hour and a half, but knowing Jonathan, we won't finish on time, we'll keep going. But in however long we keep going, we're going to try to give you a lot of very practical information about planning for the end of 2020. Specifically, what do you do with clients now? How do you implement planning? What kind of planning should you be doing? We're going to talk about a range of practical as well as technical issues. And we're going to start it with Bob talking about income tax issues, and he's going to stay on and help us with some of the estate tax issues. So hopefully the goal will be to give you a lot of practical advice, not only from a technical and tax perspective, but from a planning, drafting, and even practical administrative perspective. So just before we get going, a couple of quick points, because we have the same questions that come up every time we do a webinar. The PowerPoint is on the webinar console. So on the GoToWebinar console, if you look at the tab on your screen that says handout, if you open it up, you should be able to download the PowerPoint. We post recordings of every webinar. There's a library of well more than 50 webinars on schenkmanlaw.com under the webinar tab. This will be the most recent. It'll be posted within a week of the program, hopefully less, and the materials will be there if you miss them. They're also on the front page, a link on the Schenkman Law website. Peak Trust and Interactive Legal will also be posting them to their website, so you can get them there. There's also a library of more than 150 planning clips on Law Easy. They're less than 10 minutes each and talk about practical planning tips. Jonathan and Bob, I invite you to do some more with me so we can get some more stuff up there as well. We do not officially give CLE or CPE. We're not registered to do it. The process is just too time consuming, but you will get a CPE certificate emailed to you from the GoToWebinar system. If there's any problem with that, we can't control it. If the name isn't correct, it's whatever was registered on the system. If you have any questions, the best thing to do is email Jonathan, Bob, or I. One of us will for sure get back to you. It's better than posting them on the web console, because while we're talking, it's just hard to address it. All our emails are on the second to last slide, and we're going to get started. So first, a quick comment from our two sponsors, and then as our custom, we'll have a charity step into. Vanessa from Interactive Legal.
Thanks, Marty. Welcome, everyone. You're in for a great program today, and Interactive Legal is very happy to be a co-sponsor. For those of you who are not familiar with us, we provide automated drafting software and other resources to support estate planning and elder law attorneys in their practice. We actually have a lot of documents to support many of the techniques that you're going to be hearing about today. So I encourage you, if you're not familiar with us and you'd like to see what we're all about, please visit our website or contact us at the email address you see there. I think I'm actually going to be joining you again at the end of this webinar to read some questions that we had in a similar program that we actually had about a week ago, as you're watching this, with Jonathan and Marty. And if you are interested in that program, you can find that on the events page of our website, interactivelegal.com. Thank you very much.
And a shameless plug for Interactive and document generation software in general, with the incredible tidal wave, and it's been a tidal wave. Jonathan likes to call it a tsunami. I call it a tidal wave. But the crush of work at the end of 2020 has just been incredible, and we've seen this since probably May, maybe even before. I definitely could not get the volume of work done without using document generation software. So if you have not yet adopted document generation software, you really need to do so. Peak Trust, Nicole.
Hi, good morning. Welcome, everyone, and thank you for attending today's webinar. I'm Nicole King, and I'm a trust officer here at Peak Trust Company. We're pleased and honored to be able to sponsor today's presentation. I'd like to take this opportunity to tell you a little bit about Peak Trust. We've been in business for over 20 years, and we have offices in both Alaska and Nevada. We are a full-service trust company, and what sets us apart from other trust companies is we offer flexible and customized administration services for all types of trusts. If you have any questions, please do not hesitate to contact myself or any member of the team. Our contact information can be found on the materials for this program, or you can browse our website. And with this, I'll turn it back over to you, Marty. Thank you.
So I must have a score of trusts in process as we speak now with Peak, and they've done an incredible job administratively helping me get them through and in place. Obviously, Alaska and Nevada are trust-friendly DAP jurisdictions, which is critical to a lot of the planning. Many of the techniques that we're going to talk to you about should be in DAP jurisdictions. So if you're in a non-DAP state like Florida, California, New York, New Jersey, you need to create many of the trusts we're going to discuss and use many of the mechanisms in a DAP jurisdiction. And I've found Peak incredibly helpful doing that. And they also have a donor advised fund for spillovers on defined value clauses on note sales and so on. Now, it's been my custom for several years now to try to give a platform for different good causes, charitable causes, to give a brief discussion. And I'm going to let Jeremy Belsky from Boys Town, which is an incredible institution, say a few words. And it really, it's worthy of all of your support, not just your client's support. Jeremy?
Hey, thank you, Marty. Boys Town's now been around for 103 years, and we've obviously certainly changed with the times. We provide an array of life-changing youth care and healthcare services that meet each child and family where they are, so they get the right kind of care at the right time in the right way. Boys Town's here for you and your family with expert, compassionate care, and perhaps most importantly, especially during this time, a proven track record of helping children and families going through crisis. Residential and community-based services for youth and families are still at the center of our work. We have 55 homes on our campus. Each home has either 6 to 8 boys or 6 to 8 girls, where they receive the skills and support needed to heal before they go back to their communities. We've also expanded these services to help children and families in their homes throughout the country with our satellite offices, including Iowa, Portsmouth, Rhode Island, DC, Tallahassee, Orlando, West Palm Beach, New Orleans, and Las Vegas. Finally, Boys Town Psychiatric Care is another arm of our mission that's serving children between the ages of 5 to 17 with severe behavioral and mental health problems. So you can only imagine what that's been like this year. If you or your clients are so moved to support our mission to help change the way America cares for children and families, we'd be honored. Marty, thank you so much for this opportunity to share our impactful good work.
Before you leave, Jeremy, Boys Town is truly an incredible place. My wife and I spend, this is the only year in the last dozen that we haven't, about 2 months a year traveling around the country lecturing, and we donate all of the honorarium to different charities. And a few years ago, we had the real honor of visiting Boys Town and touring their campus and one of the homes and meeting the children. And they're really not children, they're young adults in the homes. And what they accomplish at Boys Town is nothing less than a miraculous transformation, where they take young adults who have really not had a fair shake in life and have struggled incredibly, and they create a family environment where they help them transform. It's miraculous. So I can't commend it enough, and it's a wonderful thing to get involved in. If you're ever in the area where they have facilities, I don't know, I should have asked first, but if you can arrange a tour, it's really a special experience. So thank you, Jeremy, and Jeremy's information is there and the slides in the slide deck, and don't be shy to help support it and encourage clients to support Boys Town as well. Wonderful cause. Now, without further ado, we're going to jump in, and we're going to start with Bob Keebler talking about some of the income tax issues that we're going to anticipate or may anticipate seeing. And Bob is going to also talk about the risk of retroactivity and a few other things. And I know Jonathan is traditionally shy, but I give you permission, Jonathan, to jump in when Bob talks to add your 2 cents.
Okay, well, good morning, everyone, and it's an honor to be here. Always a lot of fun to teach with Marty and Jonathan, and I've actually taught one time at Boys Town, so there was a big charitable conference out there, and it just everything that Marty said is absolutely true. They gave us a tour, and it's really amazing what happens there. Now, the general Democratic policy themes. Okay, so now remember, we're probably all aware by now that there are 2 Senate races in Georgia. If those both go to the Democrats, the Democratic Party would likely control the White House, the House of Representatives, and the Senate. On the other hand, if those seats split or both of them go to the Republicans, you will have a Republican-controlled Senate. So what would you expect if you had a Democratic-controlled Senate? First of all, additional payroll tax on high earners, an increase in the marginal tax rate on high-income individuals, an increase in capital gains rates imposed on high-income individuals. The general theme is to tax wealth, whether that's through a wealth tax, additional estate taxes, more gift tax, more GST. And a lot of the things undoubtedly in President Obama's Green Book would come back to life. So we can run through those, and Marty and Jonathan will talk about those, but every tool in your toolbox will be gone. Discounts could be gone. And I believe we taught a class a couple days ago, and Jonathan pointed out that discounts could also disappear in just through regulations. You wouldn't even have to go to Congress. Increase in the corporate tax rate is out there.
Bob, let me just interrupt you for a second. We should just comment on that. You went through something that could be very important very quickly. So let's say that one or two of the, and by the way, disclaimer that I'm going to make, I never speak on behalf of Bob or Jonathan, but I'm going to now. Anything we say is purely tax planning. We're making no political statements whatsoever on this program. But if we have the Senate seats in Georgia, 1 or 2 end up going Republican, so that the Democrats don't control the Senate, what do you see as a risk of a loss of discount? So for example, do we see 2704 regs coming back? What do you guys see being the way that discounts could by regulation be restricted or eliminated?
Well, they could certainly try to roll out 2704 regulations again. You will recall that about 4 years ago, the Treasury proposed a regulation which really tended to crush discounts. There was tremendous pushback. The Treasury got over 10,000 comments. I had actually been called about it, and I recommended to the Treasury that it not go after anything but closely held, basically artificial entities like family partnerships, but don't do it for active, closely held businesses. They rejected that, said, no, we're going to get it all. Well, they lost it all. They might come back. There's another way they could do it, and that's to change the valuation rules under section 2512 of the code for gift tax and 2031 for estate tax. There are regulations under there that tell us how to value property, from everything from life insurance policies, which are owned or transferred, not talking about proceeds, but the policies themselves, to closely held businesses, to publicly traded stocks. Now, they have a big part in closely held businesses, and it's primarily reflected by Revenue Ruling 59-60. But the service certainly could change that on a prospective basis. Keep in mind that the concept of discounts and valuation was actually one that the service itself argued for back many years ago, where an employer paid an employee with assets in kind and took a big fat income tax deduction for the value of the property given to the employee. And the IRS came in and said, no, you have to discount it for lack of control and lack of marketability. And that was, as they say, purely a Pyrrhic victory for the Internal Revenue Service, because the court said yes, it's a case called Welsh, decided back in the early 1930s, but that's now the basis of taking discounts and valuation. But the Treasury has, at least today, under what is known as the as a tax doctrine known as Chevron, coming out a very, very important Supreme Court case, which basically says that the agency, like the IRS or the Treasury, which is responsible for the administration of a law, can issue regulations, and unless the court finds that those regulations are arbitrary or capricious, a very difficult standard to meet, the courts must accept those regulations. There's even one where right after a law passed, this was over 100 years ago, the agency came out with a proposed interpretation of it. The court upheld it. It said, well, it may not be the best interpretation of the statute, but it's not arbitrary and capricious. 100 years later, they changed it exactly to the opposite, And the people who were injured by that came in and said, look, this can't be. How can they completely change it? The court said it wasn't arbitrary and capricious, and therefore we will uphold it. So the Biden administration, through the Chevron doctrine, could go very, very far in overturning things. Now, in recent days in the Supreme Court, Mitch Gans has written extensively about this, and it's in our book on Circular 230, which I must tell everyone, that is one of the most exciting books you could ever read. And in fact, if you have to give someone a holiday or a birthday or a celebration gift, wedding, bar mitzvah, graduation, whatever it is, give that book. They will love you forever because it instantly cures insomnia. But we go through that. And the bottom line is that today, some of the Supreme Court justices are saying, maybe the Chevron doctrine shouldn't be allowed anymore. But we'll have to see. But under today's law, the Treasury would have the power to drastically change the rules and for that to be upheld by the courts.
So in other words, we're not out of the woods in terms of tax planning, even if the Democrats lose those seats in Georgia. We could still see some harsh changes, which goes back to sort of one of the premises of the entire discussion today is clients should be planning now while they know what they have, because what they may get may be much worse.
In fact, Marty, when is one of those Senate races going to happen?
January 5th is what I've heard.
So we won't know until after that who controls the Senate.
Right.
So one thing is, a client can be like a deer in the headlights. Just do nothing. Well, we know that if the deer stands in the middle of the road and it's blinded by the car lights, it's going to be killed. So if your clients say, well, look, if I knew these changes were going to be made, I'd go ahead and do something. But because I know they're not going to be made, or I don't know if they're going to be made, I'm going to do absolutely nothing. That is the wrong way to proceed.
Jonathan, I'm sorry to do this, but you opened the opportunity with the deer in the headlights. Is that what happened to the fella on the wall behind you?
Well, actually, Marty, that is a deer from Texas. I had a great time down there hunting a few times ago.
You asked for that. I'm sorry, Bob.
So let's jump up one more page, please, guys. Now, we'll talk about this, but retroactivity. Can a law be changed retroactively? Supreme Court says yes. That's Carlton, R.A. Gray. So this is a risk. What that means is middle of next summer, Congress could change something back to January 1st, 2021. That's why there's been all this excitement and fear and why everybody's running so hard towards the year end. Let's go up to the next page. Now,
just a quick comment, Bob. I mean, that's a reason why if clients have planning and process, there's no question that this blue wave or Democratic sweep that the pundits and pollsters have predicted did not happen. I mean, it clearly did not happen. But nonetheless, because of the comments Jonathan made about regulatory authority that a President Biden could exercise, and because of what Bob just talked about on slide 11 with retroactivity as a real risk, it makes really very little sense to cease or stop planning that's already along the way. We have only had in my practice one client that has stopped planning, and frankly, it had nothing to do with the election. It had to do with outside third-party approvals that became problematic. So, many clients may be asking you, well, gee, the election didn't turn out, the blue wave didn't happen. Why are we doing this? And what Bob and Jonathan just explained is precisely the answer why you want to continue.
And now some things that could happen. There's a proposal that once you earned 137 on for income for Social Security purposes, that you'd have a holiday up to 400,000. So once you earn 400,000, your Social Security tax at 12.4% would kick back in. Now, evidently, you need 60 votes in the Senate on that bullet point. But the rest of these bullet points, you would, if they do it during reconciliation, you would merely need 51 votes. And you may remember in about 8th grade, we learned that if there's a tie in the Senate, the Vice President of the United States breaks that tie. Now, they would restore the 39.6% rate, cap the value of itemized deductions at 28%. This year, if I give $100,000 to charity, it's going to save me $37,000. But next year, if I give $100,000 to charity, if this became law, it would only save me $28,000. So clearly, we would look at making our charitable gifts this year. On the marginal rate, we'll talk about what that calls for. It probably calls for things like Roth conversions, exercising options, etc. Now, the P's limitation would come back along with phase outs on 199 cap A. Right now, 199, you could make $1 billion, and if you were qualified, you'd get 199 cap A, 20% deduction. They're going to cap that. Let's go to the next page and talk about some of these things. Now, capital gains. Once you earned over $1 million, so if I had exactly $999,000 of all income, including capital gains, I would pay tax at the normal rate. But if I had $1,001,000 of all capital gain, everything over the $1 million, that second $1,000 would be taxed at 39.6%. This is a really big deal. And certainly if you're in the middle of a transaction right now where mom is selling her business to a child, to her daughter, put that deal together in December. Don't wait to January. There's no upside to waiting. There's very little upside to waiting, and you could really get hurt. Now, back in 1976, you may recall, Jonathan wrote another famous book, and that was the book on step up and basis. And that book is probably going to be republished in the next 4 or 5 years because everyone's proposed. Pardon me?
I just was pointing out Jonathan smiling at that thought.
Well, it would be really needed because we're going to have to understand how this works, and undoubtedly there'll be exceptions and there'll be transitional rules, and hopefully there'll be de minimis rules. But basically, you'd eliminate the step up in basis, or you would go to a Canadian system, which is slightly worse. That's gain realization at death. And they're even smart enough that if property's in trust, I believe every 10 years there's a gain realization up in Canada. So we have to pay very close attention to this. If you're in the stock market and you're worried about this, and you're not sure, you'd like to wait till after those Senate races are over, there's actually a very clever way to, if you had 2 million shares of one company, you could short those shares, and as long as you lift the short by end of January, actually technically January 26th or 27th, you would not have to realize that gain. But if you didn't lift the short under 1259 of the code, you'd be deemed to sell back in December. You can kind of do the same thing with an installment sale of property. Say you sold Blackacre from the palm of your hand to your children. You could decide to recognize that gain in up until October 15th when you do your tax return, because that's an election you can make under the installment provisions of the code, section 453. So those are just a couple of examples of where this can make sense. If this comes to fruition, your best friend is going to be your charitable remainder trust, because if I came to you and I was going to have a $4 million piece of gain on the sale of a piece of property, you could say, Bob, we can pay 39.6 on the 3 million of that, or we can drop it into a charitable trust and take it out over time. We'll never get back to that 39.6% bracket. You can get a lot of rate arbitrage. So be ready for that. I think we'll have to teach some more classes on charitable trusts if that comes to fruition, because there'll be tremendous demand for that knowledge. Let's go up one more slide.
Bob, let me make 2 points before we go on. First, what Bob said about CRTs is very true, and that's different than what you've been hearing about with CRTs as a beneficiary of retirement plans. It's just other applications of it. But keep in mind that if you have a client that is selling a business before the end of the year because they are concerned about the 39.6% cap gains rate that could apply next year, there's two issues. One, if you put money into some of that stock into a CRT, trying to defer the gain, that gain will come out under the 4-tier CRT system next year and future years over the duration of the CRT, and could be taxed at the 39.6%. So you actually may be better not using a CRT this year. What Bob is talking about, and correct me if I'm wrong, Bob, is really using a CRT next year when the higher rates have kicked in.
That's exactly correct. And in my longer presentation on the income tax part of this, we talk about that, but you could really get hurt because if you just sold this year, you'd pay tax at 20%. But if you drop it into the CRT and it comes out in 2021 through 2041 or something, that's all runs the potential being taxed at 39.6. So there'll be a tremendous amount of income tax knowledge we're going to have to work hard on.
And just one last point. There's sort of a conflict between some of the estate planning that Jonathan and I are going to get to in the next part of the program and the income tax planning. So as Bob just explained, there's an incentive for many clients to sell a family business. If they were considering an exit strategy anyhow, why not sell now at 20% rather than waiting for potentially 39.6%? But on the same hand, we're guiding clients right now to shift value out of their estates because the estate tax rules may change. So if a client, and we're dealing, and this is one of the sort of the unique situations at the end of 2020, we're dealing with clients that may have had an appraisal done or getting them done now and transferring assets now, but may still try to close a sale to a third party before year end. So in those instances, we're going to have some serious arguments with the IRS potentially. What is the value? Is the value for estate tax purposes done by an independent appraisal correct, or is the value sold to a third party correct? And the IRS is certainly going to try to argue that the sale to the third party is correct, and part of that will turn on the facts. It's very fact specific. How far down that continuum from no sale to a signed contract has the client gone, and the further down the continuum they've gone, the more difficult that challenge may be. If there's no signed contract when the estate planning is done, it may be possible to kind of have your cake and eat it too. But those are issues that we all need to be mindful of.
By the way, just to mention, a lot of people listening are going to say, yeah, I have a client who wants to sell the business, but it can't be done by the end of this year. So we're definitely going to be into next year. What can be done? They could sell it, for example, to a non-grantor trust that they create. So there are ways to get the sale done this year, but really postpone a sale to a third party until next year. But you will recognize the gain this year.
And that wouldn't be the end of the world if you could lock it in at 20%. I mean, that's the moral of the story. Now this slide. So right now, from 0 to 137, everyone pays some level of Social Security. Maybe your employer pays half of it, but it's paid. And right now we have, after that point, you're home free, no more Social Security taxes. What this law would do is from 137 to 400, you'd have a holiday. Once you hit 400, you'd come back. Now think of your doctor. Assume she makes $1 million a year. On 600,000 times 12%, that's 74,400 additional dollars of tax. Very meaningful dollars. Undoubtedly, people will try to go the S corporation route if we jump up one more slide, and they will try to shelter that inside an S corporation. But that is a loophole Congress has thought about changing, okay? And you certainly are going to have, you're going to have to take a real hard look at this. They'll probably just nail this door shut and make it so that if you have a single S corporation where you're the only employee, you're just not going to be able to get this type of deferral. And that's probably close to the right result. Where you get the wrong result is if it's capital intensive. If you had, maybe you're a surgeon, but you personally own a $2 million machine that helps you in your practice, there's got to be some return on that machine that's not subject to the Social Security tax. So we'll have to see how that plays out. Let's go up to the next slide. And one more, please. Now, if you're sitting here today and you're saying, what else can I do? You might want to exercise ISOs or NSOs. Certainly on the NSO side, you could take those NSOs into income at 37% versus 39.6. Remember, potentially, so that Social Security loophole, if that's closed, you would also get hit when you exercise non-qualified options. Today, if you exercise them, once you hit 137, no more taxes from a Social FICA perspective. Also keep in mind, AMT is very liberal right now with the bigger exemptions. Maybe a good time to exercise your ISOs. Next page, please. Now, the 39.6% rate would be restored at over $400,000 of income. If we look at, and it's unclear how this would be affected by filing status. That's what we just don't know. But that will sort itself out. Look at the next slide, though. Take your pencil and put it on just at the top of the 32% bracket in 2020. Now move that to the right, and you'll see that very tip of the 22% bracket or 32% bracket becomes the bottom of the 39.6% bracket. That is a pretty big clue if you're going to be in there that you want to pull gain into this year's return up to the 37% bracket, and you'll create some rate arbitrage. Now, remember, when you run the numbers on this with interest rates so low, the cost of capital isn't that big. It's not like it's 1979 and you can earn 15, 20% interest on your money while it's sitting there. You're earning very low. So to pay some taxes up front probably isn't going to hurt a lot of people. One of the big things here is Roth conversions. We're actually working very hard on that. We're fine-tuning a program now that will help us by doing a lot of Monte Carlo and asking ourselves, what happens if the husband dies at age 75 and his wife lives to 85 or 90? How much better is a Roth conversion? Because if we go up one more slide, please. Because what you have to remember is that if I die with a $4 million IRA and that's our only asset, my wife is going to be filing a single return shortly the year after I die, right? And those single rates or single brackets are half where the married brackets are. Getting money onto the Roth side definitely makes sense. And if you're doing conversions at 37, if your permanent tax bracket is going to be 39.6, rarely can you hurt yourself by doing a Roth conversion. Now, the other thing that's conceptually out there is harvesting gains.
Bob?
Yes.
Just sorry to interrupt. On Roth conversions, I think that may be something important for estate planners to be aware of, even if that's being handled by, for example, the client's wealth advisor or accountant. If I'm having clients that are planning to put $11 million of securities into a slat, and they're going to convert a large IRA to a Roth, the key to the conversion is that you want to pay the income tax on assets outside of the IRA. But that may affect the modeling of how much I can put into the slat or other trusts that we're doing. So I think, you may want to comment, or Jonathan may want to comment, but it just seems important that estate planners that may want to stay in their swim lane need to make sure they're aware of what's going on in the Roth conversion lane, because it just may affect the liquidity that's being used to fund a slat or other irrevocable trust.
One other thing that I'll mention is that Bob is absolutely correct in what he's stating about the current law. But the Congress has retroactively taken away tax benefits which it promised the public it would get. For example, under the Tax Reform Act of 1986, people who had entered into completely legitimate government-approved tax shelters were told, no, you can't get those write-offs anymore. Yeah, we'll give you a couple of more years, but we're taking it away retroactively. So don't think that later Congress might come back and say, yes, we told you that everything that comes out of that Roth will come out free of income tax, but we need the money. And as a consequence, yeah, we won't tax again what you've already paid tax on, but we will tax the additional growth inside the Roth IRA. So keep in mind that one of the things that we cannot forecast are changes in the tax law. Some are obvious. What will the brackets be? What kind of deductions will be allowed? At what rate? But the other thing is they may completely change the basic structure of what is taxed and what is not. And that's something that's impossible to forecast because it is a political decision.
One of the things that's important to do as practitioners is what Jonathan just said, and Bob was talking about, affects everything we do. We don't have any crystal balls. The best we can do is the best guess that we can make based on the knowledge we have while we're doing the planning. Consider incorporating into your billing arrangements, engagement letter, retainer agreement, a caveat, a disclaimer, just advising clients that tax laws are uncertain. Tax laws can change. They can even change retroactively. A couple of sentences like that in your standard engagement retainer agreement can be very protective, so no client can argue that they weren't informed that the planning that they were doing may not work as anticipated. And that's the case with basically everything we do. Bob?
So thank you, Marty. Now, the other thing is to look, and we kind of addressed this a little bit, but think about harvesting gains. If your client needs $500,000 next year to pay off a mortgage on a cottage, raise that $500,000 in December, not in January. Just don't take the chance of the tax on the capital gain going up. Deferring loss harvesting, if you think you're going to be in a higher bracket next year, capital gain wise, is smart. And also for many of us, deferring business expenses will likewise be smart. Now, on the Roth side of things, what I think really every estate and trust lawyer should do is when people come in, if they have a sizable IRA, 250 or above, 500 or above, just say to the client, have you spoken to your financial advisors and CPAs about doing a Roth conversion? And I think, and do it with every single client. Then if anybody ever says you didn't tell me this was an option and they're suing you or something, you can say, no. Every client since November of 2020, I have mentioned this to. I'm 100% certain of it, because it's unclear really whose responsibility it is to bring this to the client's attention. I certainly do not think estate and trust lawyers has a responsibility. I would say no. But on the other hand, to protect yourself, you may want to bring that up and throw that back into the CPA's court. Now, we go up one more page. Here's the interesting thing. In a nutshell, they would take, on the Democratic side of the aisle, they would take the benefit of your itemized deductions from 39.6 down to 28. That means that if you're going to do charitable giving this year, you'd be inclined to do it in December. Now, I'm going to give you just the opposite advice on SALT. Strangely enough, your state and local, like property taxes, state income taxes, you're probably wise to pay those once you go over $10,000 in January of 2021, because what Vice President Biden, President-elect Biden would like to do is bring that back, bring back those SALT deductions. And that's something that Congress has been very divided about. Okay, now if we go up a couple more pages, please. And the P's limitation would come back. Those of you that do tax returns know exactly what I'm talking about, in something that the software will do for us. Now, the more important things on page 24. No one knows what this is going to look like, but we would lose some of our 199 cap A deduction. So the thing about this is, if this comes to fruition, you will be grateful if you bring income forward. I just had this conversation with a client, and he's on a cash basis, thousands of apartment units. And I said, you need to have all your managers bring those checks to the bank that come in on December 28th, 29th, 30th, and 31st, get those deposited. Because right now you're paying tax on 80 cents on the dollar. So why wouldn't we try to get that money in the bank, okay? So that just makes sense. Looking at the next page, C Corp and S Corp rates will also change. The S Corp rate will change by going to 39.6 and losing 199 cap A. On the C Corp rate, probably goes to 21%. One more page, please. Now, the capital gain. We kind of spoke about this, but what you need is a holistic plan if this happens, because Clients are going to be more willing to sell during lifetime. We're not going to be hanging around for that step up in basis. If indeed the step up in basis goes away, I'm more inclined to sell. And I think the job of the financial advisor is going to be to help me stay below that $1 million each year. Now, some people that's going to be impossible, right? But for most people, we can keep them below $1 million by smoothing out income. So the financial advisors and the CPAs are going to have to work very hard on that. And Marty brought it up very astutely. I have a little note there in the red box. You do not, in all likelihood, you do not want to do a CRT in 2020. You might be better just to absorb that gain or use some other planning device. The next page is just a quick snapshot of how this would look. Look at the upper right-hand corner, please. Once you hit $1 million, the rate becomes on capital gains and qualified dividends becomes 39.6%. Now, here's something very interesting on the next page. We built this little calculator, and Vince Lackner is actually at 6-in-1 Software, is actually looking at programming this and making it available. But what this does is shows you, is it smarter to sell early? Now, if both tax rates are 20%, the answer is no. That's clearly what this says. You should do nothing. Why would you sell early if the rate was going to be the same? But look at the next page. This is crazy. If the rate jumps from 20 to 39.6, it says we should be selling in December of 2020. And unfortunately, we're not going to know this till that Georgia Senate race is over on January 5th. It puts you in a terrible spot because it'd be easier for clients to say, okay, I have the courage to do this, because it takes, courage to pay a tax way before it's due. But what this says is you can go out even 5 or 10 years mathematically, and you're better to sell if you're going to cut that tax rate in half. So put that in the back of your mind. That's worth looking at. Now, the 39.6% capital gain rate is going to mean, if we keep the step up in basis, it's going to mean people hold stuff forever. And if we lose the step up in basis, people might not care because they're going to be more worried about smoothing out the income and trying to avoid these super concentrated positions. So I'm working on a very large trust right now with some GST problems, and the portfolio is crazy. About a third of it is in one stock with almost no basis. And I don't think that behavior would have happened if the step up in basis was eliminated, because people would have been willing to pay tax along the way.
Hey, Bob.
Now, yes.
This is really kind of tough. If we lose basis step up, which we don't know what's going to happen, then, and if we have the higher capital gains and no basis step up, then you're going to be focused on timing when you sell your capital gains to try to suppress it under the $1 million level. If we have the higher capital gains but basis step up remains, then you'd want to hold everything till death. I mean, almost polar opposite kind of planning scenarios.
It's almost polar opposite, and I think portfolios might be more focused on buying the QQQ or the SPY and just having these highly diversified index funds, so that then you don't end up with this situation of one stock with that tremendous gain. Now that's for the financial advisors to sort through what's the best strategy, but you can see how this is going to change. Wow. And we have to watch that step up. Now, one more slide, please.
What are you telling clients now, though? Because it seems like, depending which way the rules go, we could have just such opposite information. What would you tell somebody to do now?
Well, 3 or 4 things. One is, if you have a publicly traded security that you think you need to sell in the next 5 years anyway, but you'd like to wait to after the Georgia races, you can borrow an equal number of shares, go short against the box, and you can decide whether you're going to recognize that gain in December, as late as end of January, because you can under 1259 of the code, you can simply leave that short against the box in place, and the constructive sale rules will trigger that gain. The person that taught me this is a gentleman named Mark Fichtenbaum. He's a professor at Pace University and just a wizard. He used to work with Bob Gordon at 21st Securities, just an absolute wizard on these rules. But when you go short against the box, you're deemed to sell the securities unless you lift that short by the end of January. So that is something that if you have somebody in that situation, by all means, reach out to somebody like a Mark Fichtenbaum, or I'm sure there's many tax accountants and tax lawyers in Manhattan that would understand this. Major transaction, okay? Now, we could also do installment sales. I sell a Blackacre to a non-grantor trust for my children, and we basically could elect out of installment sale treatment as late as October 15th, 2021. So that would give you a long time. You'd know what the law is by the time you're doing that tax return. And if not, you just recognize the gain when money comes in under the installment method if you decide not to elect out. The other things that are out there is for next year, we would be looking at charitable remainder trusts. That would be something to smooth out gains. All of us will become smarter on opportunity zones, 1031 exchanges, non-recognition partnerships. There'll be a lot going on here, and we'll undoubtedly have to build specific classes, Marty, around this 39.6% capital gain, because everyone is going to have to, especially me, is going to have to go back to school and learn, how to finesse these things.
Bob, when you say non-recognition partnerships, are you talking about investment partnerships that avoid the investment company rules so you can in fact diversify without triggering gain?
Exchange funds, right?
Yeah.
You bring together, Wall Street firm brings together 200 executives with different stock. They throw it into a partnership. And
what do you need, like 20? I think you need 20% non-marketable, like real estate or something, to make it not fall out of the investment company characterization.
Yeah, the rules are all governed under 351 actually, which
351E, I think.
And then
721 and 351E.
Yeah, you have to. They usually use some preferred stock in there to avoid recognition on this. Okay, next.
Lots of fun, folks.
Yeah, no, this is lots of fun. Next page now. Maybe Jonathan jumps in here, but imagine if we go as far as a recognition event at death. And if we do that, you could have both a state tax and a recognition at death. Depending on how if you go up one more page, Marty, depending on how they order that. Current law, I die, I have $3 million worth of stock, and we pay tax, we pay an estate tax on that. Let's assume I have all kinds of other property. If they give us a 691C deduction, that would give us the amount that would go to our family would be about $1 million. If you had to pay both income tax and estate tax, you still get about $1,088,000 to your family. But if somehow you do not end up with a 691C deduction or a 2053 deduction, you could end up with literally $3 million turning into about $600,000. So we got to watch this and see how it's going to work, because we need a mechanism, and the law allows for this right now. But if I have a gain at death, hopefully it's on my final 1040, because then that it would give rise to a 2053 deduction on my 706. However, if the gain is on my 1041, then you just hope that the IRS looks at that and allows you to get a 691C deduction. All things being equal, the 2053 deduction is usually more valuable than the 691C deduction for the income tax deduction for the estate tax paid.
Sounds like we may all want to be getting our insurance licenses.
Well, great point. Well, depending where the de minimis rule is, say the de minimis rule is $1 million, that would mean there'd be a lot of people out there that say, okay, I have $5 million gain. I'm going to go out and buy $1 million of insurance, or I'm going to buy $2 million of insurance. And what's not clear is and I don't know the Canadian rule, maybe Jonathan does, but what happens if I just leave stuff to my wife? Is there a recognition event at my death, or can that?
No, there's a marital type waiver or deferral. So if you leave something to your spouse, you don't pay the tax then. The gain is carried over until he or she later dies. But under the Canadian system, you pay a gains tax, which may be ordinary income or capital gain, depending upon a variety of factors. If you die with the asset, if you give it away during your lifetime, if you move out of Canada and become a non-resident of Canada, even if you remain a Canadian citizen. So all of those things can trigger gain. Now, Canada repealed its estate tax when in 1973 it adopted the capital gains tax at death. So they didn't have to deal with whether or not you'd get a deduction or an offset at all for the capital gains tax paid, which is on, by the way, the decedent's final return. Based upon what happened in 1976 with carryover basis, I'm reasonably certain, Bob, that your number one, the one on top, proposal without a 691C or a 2053 deduction would not apply. And in fact, in 1976, when they put in the carryover basis rule, they dropped the estate tax rates from 77%, hard to believe they were that high, but they were federal alone, down to 70% to kind of take away some of the sting of having carryover basis. We simply don't know what would happen. And there is a third option, capital gains tax at death, carryover basis, which of course I'm rooting for because, as Marty and Bob said, I can dust off my book and finally have a bestseller, because the carryover basis provision under the Tax Reform Act of 1976 was retroactively repealed in the Windfall Profits Tax Act of 1980. But the other one, which in a lot of ways is sensible, is to just repeal Section 102 of the code and to provide that gifts, bequests, and inheritances are includable in gross income. In fact, some of you may have had the same experience I've had. I've had a client or a relative call and say, listen, I inherited $100,000 from my Aunt Tilly. What kind of income is that? Where do I put it on my 1040? And the answer is you don't have to pay tax on it. And they go, what? And they go, yes. I mean, if you think about it, you win the lottery, you pay tax on it. You get lucky enough to have a wealthy relative die, you don't pay tax. That's because of 102 of the Internal Revenue Code. So that might be another way in which they decide that it would make sense to go ahead and not allow the appreciation to permanently escape taxation.
And thanks, Jonathan. Marty, let's jump over this slide and let's go right into yours and Jonathan's thoughts on documents in a COVID environment.
So let me take 5 minutes. I'm going to go through this at breakneck speed because I just want to build some awareness of how COVID has changed what you may want in estate planning documents. And we're going to then jump into the estate tax planning at the end of 2020, which is what you want. I just think this is worth just having some awareness of. COVID has changed everything. One of the things on slide 36, it's not only about our clients. We should ask clients, do any elderly relatives, parents or otherwise, that you care for or are caring for, do they have estate planning documents in place? If somebody gets sick, it's certainly dramatically easier and less costly and less problematic if they have documents. Kids going off to college, do they have basic documents? At minimum, a health proxy and a power of attorney, but why not do a simple will? And with document generation software, we should be able to do this stuff at a very nominal cost, as almost as a courtesy will, if you will, for our clients. Powers of attorney. And I'm going to skip all the basics, assuming you all know what they are. I'm just going to point out the COVID implications. So one of the things to consider in COVID, many powers on slide 40 are springing powers. They spring into effect on disability. That has always been kind of an issue in some states. Florida, as an example, don't accept springing powers. But in a COVID environment, especially right now, COVID is surging. Are you going to take an elderly or infirm or ill family member, loved one, to a physician to examine them, to give you the letter that's typically necessary to spring a springing power of attorney? Are you going to expose that family member and yourself to COVID? Is the physician going to, even with hospitals being overrun, be willing to spend the time on something like this. I think the better course of action is if you have clients that have springing powers, talk to them and make them immediate powers, redo the powers of attorney. Another issue, which we're going to come to in a second in the context of health proxies, is electronic decision making, and we're going to talk about that. Living wills, DNRs, there's an issue unique to COVID. Take a look at slide 45. And I'm going fast because you have the materials. Again, I'm just trying to build some awareness if you haven't heard these concepts. But all the basic core estate planning documents we all have traditionally done all need to be rethought in light of COVID. So one of the problems, and I actually spent some time and researched online free living will forms, a tremendous percentage of the ones that at least I found had blanket prohibitions against intubation. Well, if you contract COVID, you know, intubation is not perhaps being used with the same degree as it had when COVID first began. They have other approaches, but clearly for those that are in dire straits and very ill, intubation remains a means of perhaps helping you survive COVID. Why on earth would anybody want a living will that has a blanket prohibition against intubation? It may be your death sentence if you contract COVID. I think what most clients had in mind, and drafters who created these online forms had in mind, and even some lawyer forms that I've seen, was that, you know, if I'm in a terminal state and have a month or two to live, I don't want to be put on a ventilator. I don't want tubes and so on and so forth, and extraordinary measures. That's different than COVID. So we need to tell clients that if they have documents that have mandatory blanket prohibitions against intubation, they may want to revise those immediately. In the bottom of 45, experimental medical treatments. I mean, isn't everything that's being used to treat COVID experimental? I think you want to expressly provide you do want experimental treatment. Healthcare proxies. Take a look at slide 48. Just a thought on that. You know, we've all heard these heartbreaking, tragic stories of people that have died without being able to have their loved ones at their bedside in a hospital. And that's sadly become a very common storyline of COVID. And often it's, you know, and you hear those stories as well, it's only through the graciousness and caring of a nurse that gets a FaceTime call or an iPad or something and enables somebody to say goodbye to a loved one. Well, you're not going to get into the hospital as an agent. In the old days, pre-COVID, if Bob was my agent, I was going to name Jonathan, but not after seeing what happened to that deer. If Bob is my agent, he would go to the hospital, talk to the physicians, make a decision, sign any paperwork, and whatever had to be done would be done. But Bob probably will not be let in the hospital. They're too busy. COVID is too contagious. So what do? And I think the answer is, and this is along the lines of something that we don't have in here, but we've done other programs on, which is, and if you want materials, email me, I'll send them to you. I did an article for Lissy on electronic will signing. But what do you do to make decisions if my agent Bob can't get to the hospital? So I have a sample clause I created in the bottom of 48 that you may want to incorporate into healthcare proxies, where I expressly authorize Bob to communicate medical decisions with medical providers via FaceTime, Skype, web meetings, et cetera, sign documents to approve medical decisions electronically, et cetera, and hold harmless the medical providers for a decision Bob makes in that manner. We need to rethink everything. And by the way, I think one of the things that's going to come out of COVID is all the ways documents are signed is going to be rethought. Hopefully the electronic emergency measures that many governors enacted will become permanent, and we will rethink electronic wills and everything else. And just a final point on core documents, so we can spend the time getting into the planning, is revocable trusts. I've used those as a default for many years. I just feel they're far superior to a will, even though in the areas where I primarily practice, New York and New Jersey, wills remain the most common vehicle. I prefer a revocable trust because it's a better vehicle to deal with disabilities and aging issues. I like to assign a tax ID number to it. I like to get the revocable trust fully funded. In COVID, where you have an elderly or ill or infirm individual underlying health conditions right now, it's not prudent for them to go out to a bank or anywhere to transact business. But if everything's in a revocable trust, you may be able to do all of that through the agent, the successor trustee or co-trustee appointment. So rethink everything we're doing. That's really kind of the message of those of that discussion on core documents during COVID, and that should not be off radar, even though we're all consumed with tax planning. So now the next part, which is an important part of our whole discussion, is what should be done now, and what are we working on in late November, December of 2020. Jonathan, why don't you give a little overview and introduction for a minute, and I'll be right back. Just why are we planning to shift assets and how are we doing it? And I'll be right back.
Well, of course, the notion is that we want to get transactions done prior to any adverse changes in the estate tax or related income tax laws, whether that's capital gains tax at death or capital gains at gift. But primarily, I think it's focusing on two things. One is a potential reduction in the amount of the exemption. Now, as we know, 11.58 million. It will be 11.7 million in January, unless there's a retroactive change. And as Bob has pointed out, the courts have stated, the Supreme Court has stated that Congress, yes, can make laws retroactive at least to the beginning of the tax year in which they are adopted. So you've got an 11.5 million as a practical matter exemption. And maybe you say, well, gee, I am worried it'll happen, so I'm willing to give away, say, $8 million, because I think the exemption will never go below 3.5 million. And there are two factors in that. One, do you really wanted to give it away to grab that exemption? And you're almost always better off using an exemption as early as it's available. But you're also concerned that, maybe you'll lose access to it. And we're going to talk about how you can maybe get access to property you've given away. But suppose the client says, look, I'd be willing to give this property away, but only if I really thought these changes were going to be effective right away. We know that come 2026 under current law, which of course could itself be changed, the exemption will be cut in half. So we go from around 11.5 million to someone in the neighborhood of 5.7 or 5.8. But you think, nope, it'll never go below 3.5, so I'm willing to give 8 million away, but only if I really think it's going to happen. How can you do it? How can you give property away now before any potential change and yet take it back if it doesn't happen? Because we're not going to know until after January 5 whether the Democrats or the Republicans have it. We also don't know what kind of deal is going to be made, because they have to do a budget reconciliation act, and maybe the Republicans will say, you'll never change anything about the estate tax. That's number one in our lives. But on the other hand, the Republicans might say, we'll give up a little bit in the estate tax for other things. For example, for not trying to increase the capital gains tax rate. What can you do to give it away but get it back? Well, there's something, and I want everybody to write it down. It's section 2518 of the Internal Revenue Code. You all know about that. That's the disclaimer provision, which went into effect under the Tax Reform Act of 1976, which basically says if you offer someone either during your lifetime as a gift or to someone as a bequest when you die, and that person doesn't accept the property and disclaims it, refuses to accept it within 9 months of the offer, or if it's a minor, within 9 months of becoming the age of 21, it will be pretended as though that transfer were never made. Can you do that now? I believe you can, but you have to be cautious. Now, let me mention that the first big tax court case I was ever involved with, and you may really want to write this down, is the estate of Edward Honig, H-O-E-N-I-G. Mr. Honig had been a lawyer in New York for almost 60 years. He married very late in life, and he married a much younger woman, which is what Bob and Marty say they're going to do for the next spouses for them. But in any event, he married this younger woman, and he knew because he was older and male, he was going to die first. Well, guess what? She died. And under her will, she left her entire estate to him. Well, that was bad because it meant that all of their property was going to be taxed in one estate and push his estate up into much higher brackets. So we found out about that, and I prepared, one of the first things I did, I prepared a disclaimer under New York common law. New York had not adopted a disclaimer statute for bequests. It had one for intestacy, but it didn't have one for bequests. So I prepared this disclaimer for Mr. Honig to sign, and he went and I took it over to his house, and when I rang the bell, the housekeeper came out and she said, I'm sorry, Mr. Honig isn't feeling well, come back tomorrow. Mr. Honig died that night. Well, Morgan Guaranty Trust Company of New York was the executor, and we had Morgan Guaranty Trust Company of New York as his executor, the executor under his will, do the disclaimer for him. And the IRS said they would not accept it. They said, you just can't do that. Well, my dear longtime friend Mitch Gans and I wrote the winning brief, and the tax court accepted exactly what we said, which is that under New York common law, an executor could make a disclaimer. It was done in a timely manner. It was done about 30 days after Mr. Honig died, and therefore he was not deemed to have accepted his wife's estate, and therefore it didn't become part of his estate. That, by the way, and you ought to take a look at it, is 66 TC page 471, 1976, 66 Tax Court 471, 1976. Now, later that year, on October 4, 1976, I remember the date, Gerald Ford signed the Tax Reform Act of 1976, and we got federal rules for disclaimers under Section 2518. And virtually every state, and I think by now every state has now statutory rules of disclaimers. And that means that you can put in your trust that the trustee can disclaim the property offered, and if the trustee does, it will revert back to the grantor. And that means you can have it redone. You'll have 9 months. If you do this on December 1st of this year, you make the gift to a trust. The trust says that the trustee, and I would make sure it's an independent trustee, not a beneficiary. It would just complicate things if it's a beneficiary, can disclaim. And if the trustee does disclaim, the assets will revert back to the donor. And you could do that by August 31st of next year. You have a long time, maybe not the October 15, which Bob talked about, and I'll talk about maybe one way you can get that done as well. But you'd have 9 months to decide, do I really want to use exemption? Do I really want the gift to be made? Or do I want to take it back? And that's going to be up to the trustee.
Aren't you worried about the fiduciary duty that the trustee has to the beneficiaries?
Well, Marty, you're going to put in the trust that the trustee can do this without regard to fiduciary duty, because the trustee can consider the entire situation, including what the donor might do if the trustee does not disclaim, and I think you can certainly protect it. Now, under Alaska law, you have to make sure this is valid under state law. In Alaska, under statute, you might want to write this down, 13.70.030 B1, it says expressly that a trustee may disclaim, provided the instrument authorizes the trustee to disclaim. Unfortunately, that is not the case in all states. For example, in New York, in the Estates, Powers, and Trust Law, Section 2-1.11, the New York Disclaimer Statute, it expressly provides that an executor under a will can disclaim exactly what happened in the Honig case, but it doesn't expressly say whether or not a trustee can. Now, you might argue, well, New York kept the common law disclaimer rules, and since we use that for the Honig case, because we didn't have the statute, you can probably do the same with respect to a trust in New York. I wouldn't take the chance. I don't know what other states provide. Marty, do you know whether under New Jersey law a trustee? No, Marty doesn't know. Bob doesn't know about Wisconsin. Take a look and see. If in doubt, I would suggest you create an Alaska trust and expressly provide that the trustee can disclaim pursuant to Alaska statutes 13.70.030 B1. That way it can be undone, and you will expressly provide that the trustee is not liable to anyone for exercising or not exercising the disclaimer.
And why are you concerned about a beneficiary having a power to disclaim on behalf of all the...
Well, maybe you can, Marty. You know, we all use disclaimer trusts where we set it up that it's all going to go to the surviving spouse, and we provide that to the extent the surviving spouse disclaims, it will go into, say, a family type trust. And, you know, I think we're all comfortable that that can be done. But remember, only thing she is giving up, or he's giving up, the surviving spouse is giving up, is his or her right as a beneficiary. She's not necessarily doing it on behalf of the other beneficiaries. I would feel comfortable if I didn't want to go to Alaska for some reason. I would feel comfortable saying that this named beneficiary can disclaim, and if he or she disclaims, because they're the primary beneficiary of the trust, it all goes back to the donor. I think you're better off following a state that has an explicit rule for trustees to disclaim. I don't think you'll have any problem with the Internal Revenue Service. Now, that's something that I would suggest you seriously consider. Now, there's
Jonathan?
something else you can do if you're married to a U.S. citizen, as Bob, Marty, and I do. You can create a Q-tip type trust described in section 2053F and provide that it looks like a perfect Q-tip trust. Your spouse is the sole beneficiary for his or her lifetime. No one else can receive a distribution during his or her lifetime. And it will qualify for the marital deduction, however, only if the donor, that's you, the guy or gal who created the trust for the spouse, elects to have it so treated on your a gift tax return, your Form 709. If you don't make it, it's not going to qualify. And if you don't make the election to have it qualify for the marital deduction under that section, then you're going to use exemption. But you could elect, and that way it'll qualify for the marital deduction. And maybe you trust your spouse and you trust the trustee. So I do this. I have my brother Doug as the trustee. Doug then invades the trust for Betsy. We haven't paid any gift tax. We haven't used any exemption because I've elected to have it qualify for the marital deduction. And I can do that by October 15 of 2021. The property would go to Betsy, and Betsy could turn around and give it back to me. So we can undo it that way. Now, what you cannot do, I believe, is use a Clayton type Q-tip. Clayton was a very famous case, and even though the IRS fought it rigorously, it finally threw in the towel and issued a regulation under section 2056B7, which said, if you provide that the trust will not continue to be a Q-tip type trust, income to the wife or the husband for life, no invasions, but you have it go into a family trust to the extent that the election under section 2056B7 is not made, it will not cause it to fail for the marital deduction. Why would it fail? Because 2056B7 is clear that no one, not even the spouse, can have the power to give any part of the trust to anybody else during the survivor's lifetime. Well, if you provide that to the extent the election isn't made, it's going to go into a family trust where assets can go to, say, kids and grandkids as well as to the spouse, well, it looks like it didn't qualify for the marital deduction. It didn't ring all the bells that are necessary to have a good Q-tipable trust. But the IRS issued a state tax regulation under section 2056B7 and said, okay, we'll let you do this for estate tax purposes. You can provide that to the extent your executor does not elect for Q-tip treatment under that section, even though it could be elected, and to the extent it's not elected, it goes into, say, a family trust. It's no longer in a good Q-tipable form. We say that's okay. So if the election is made, qualifies for the marital deduction. If the election is not made, you'll use a state tax exemption. But they never issued a regulation or gave any hint that they think it's okay for gift tax purposes. So I would say you're going to have to be even more courageous than Marty is. And let me tell you, Marty is a very aggressive, very, unbelievably forward-looking, aggressive type practitioner. But Marty, I'm not even sure you would do it for a lifetime gift.
So let me give a different spin on some of what Jonathan said, because we're all facing a deluge of clients looking to plan. And the techniques that Jonathan just gave you are creative ways of getting a client the ability to take when we were kids, remember we said no backsies? Well, this gives us backsies in a tax planning environment. And for clients that are hesitant about planning, that may be an interesting technique. But let's take a look at slide 60. Based on everything that Bob and Jonathan and I had talked about earlier, the exemptions could go down, GST issues, we could have a GST tax every X number of years. There's a whole range of things that could happen, and it could be retroactive. If we create robust, flexible trusts, if the assets that transfer into the trust, if the trust provides access to the client, we're going to talk about that, and we use exemption, and it provides asset protection, why would you not want assets in a trust? So I think that even though some clients are uncomfortable because they're not used to trust planning, To the extent we can help shift wealth while we know what the law is, and Bob in his discussion made it pretty clear we have no idea what's coming down the pike, and we won't know till next year, and it could be retroactive. Why not shift value now? And I think that's clearly what's driving planning. Slide 61. One of the things, and this goes back to some comments Bob made, and let me just reiterate it here. I think the best way to do planning is as a collaborative team. Bob pointed out a range of income tax issues, and I kind of highlighted how some, like the Roth conversion, can affect what we're doing from an estate planning perspective. But if you're going to do estate planning, you want the estate planning attorney, the wealth advisor, the accountant, the insurance consultant, all involved. Insurance is critical to all this planning. I try to recommend to every client, whether they do it or not, consider life insurance. So if I'm doing non-reciprocal spousal lifetime access trust, one of the exposure points is if the spouse dies prematurely, the spouse that created a trust will not have indirect access to that trust through their spouse who's passed away. Life insurance is a simple and easy way, if somebody's insurable, to address that financial risk. Making sure clients have adequate long-term care coverage and property casualty coverage and so on and so forth before large asset transfers is something that's helpful. So let's do all this as a team. Now on slide 62, and we'll do as much as we can in the time we have, but we're going to have to talk fast, Jonathan. We're going to talk about some of the ways that we're seeing a lot of planning happening right now at the end of 2020. Spousal lifetime access trusts are almost a default plan, but it's really not enough, and there's some tricks and tips and things that need to be thought about with spousal lifetime access trusts. Self-settled trust, domestic asset protection trusts are something that should be on your radar and in your toolkit. For clients concerned about the keyword, which we said on slide 60, access, we got to make sure that unless the client is uber wealthy, that relative to the assets transferred, that they have access. So DAPs, hybrid DAPs, SPATs. We're going to briefly talk, if we have time, about GRATs, and we'll see how far we get with some of the other techniques. Now, one of the key points on slide 62 is to protect us as practitioners. It's important that we offer clients options and let the client select what we do. We don't want to offer just one technique and then have the client later complain, gee, that doesn't fit my purposes. Now, some of the things that I think are important, and I think this is another point or perspective on what Jonathan just discussed on ways to get things back. If a client starts the conversation being hesitant to plan, if the client starts the conversation by wanting to be able to undo the planning, you have to pause and ask your question. Why is the client doing that? If the client is so hesitant to do planning, is it really advisable to do the planning with the client? And it may not be. I don't think any of us want to be in a position of trying to convince a client to do planning, and then the client later or the heirs are unhappy that the planning was done. Gifts of promise. So one of the techniques that some people have talked about is making a promise and using that to use exemption. I'm going to make a few comments and then let Jonathan comment on it, and Bob may want to as well. Again, one of the questions I think you need to ask, apart from does it work and how to structure it if you are going to do it, is why is the client looking at this? Now, I have a client that has a very sizable estate, but we're having difficulty in the amount of time left before the end of the year getting third-party approvals from lenders and others to make the transfers. So they may just opt to use a gift of a promise because we can't move assets in time. So that's a reason that makes sense. If the client is pursuing the disclaimer approach, a gift of a promise because they have tons of money in their brokerage account, they just don't want to part with it, you need to ask why. And I guess what I'm getting at is we want to be cautious as practitioners. We don't want to appear that we're arm twisting to get a client to do a plan if the client's uncomfortable. And when a client acts hesitant or uncomfortable, I offer them, listen, you don't have to do anything. The law may not change, but if it does, you may have lost out. Let the client make the decision. You don't want to be in the position of a client later coming back and saying, you know, my attorney pushed me to make this plan and I'm not comfortable with it. Jonathan, do you want to talk briefly about a gift of a promise?
Yeah, this is something that was really spearheaded by my former Milbank colleague, Austin Bramwell, and it's really a great idea for someone who doesn't have adequate assets now. And there are other ways if you just don't want to give away your assets. For example, maybe they're highly appreciated and you don't want to give them away because you think that the tax-free step-up and basis will be there. You've got to find a jurisdiction where it's enforceable, because normally if you make a promise to someone, even in good faith, even if it's in writing, it's simply not enforceable and won't be a gift. But based upon a case decided by the Seventh Circuit many, many years ago, it appears if you make a promise which is enforceable, it's a gift. Now, one of the ways you can try to do it is to say something like, I promise to give you, my child, $11,580,000 if you promise to read a book every month for the next year. Now, obviously, that consideration you got back is not really something in money or money's worth, and it's certainly not worth the $11,580,000 which you promised to transfer. Now, you can try to go ahead and do that, although I would not make it something like just an act to read a book. I would have it something coming back. I promise to wash your car every week for a year, and I promise to give you $11,580,000. That presumably would be enforceable under the law of most states. But I think the best thing you can do is to go to Pennsylvania, and Marty has cited the statute there. Pennsylvania basically provides that if you make a promise to a delivery of property or an amount in writing, and you say that this is enforceable, even though it is not for full and adequate consideration, that is enforceable and should work. That means you will give a note to the trustees saying what you're going to do. I personally, if I did this, and I'm thinking about doing this myself, for example, because I'm going to confess, unlike Marty and Bob, Betsy and I do not each have $11,580,000 to give away. So if we want to use our exemption, we're going to have to do something like a gift by promise. And so we do it. We will now have made gifts, and there's a revenue ruling 84-25, which is cited there to say, even though when you make the gift, that would be an adjusted taxable gift and would be taken into account to push your estate tax into higher brackets when you die. If it's a gift by promise, then we will wipe out that adjusted taxable gift. So you'd make a gift, you'd use exemption, but you would not have to count it as an adjusted taxable gift. So that's a pretty good way to go. But I would consider doing it in Pennsylvania. In fact, I would get a Pennsylvania trust with a Pennsylvania trustee and follow along with Pennsylvania statute 33, section 6. That's what I do. Now, I would also provide, and Austin and I, at least initially, had a little disagreement on this, do you have to provide for interest? Well, I want to say that that has to be paid by the time I die. Well, if I make a promise to deliver $1 million to someone 20 years from now, and I might live 20 years, it's not worth that amount right now. So you need to provide for interest. Can you provide just for the AFR? Well, I'm not sure that's adequate, but I would at least do that. Maybe they would argue, well, it's not worth exactly the $11,580,000 because the interest rate doesn't really fall under the safe harbor of section 7872, where you can use the applicable federal rate, which now, by the way, is about 1.3%. So you're making this promise, you're going to pay it with interest accruing at 11.3% or whatever the applicable long-term rate is. It probably will be long-term unless your client has a life expectancy of under 9 years. And I think that that's really a good way to consider. Now, Marty, do we now have the defective partnership for the next slide?
No.
Okay, let me
gotta hold your horses. So let me go back and revisit this point. I think you need to be careful to understand why a client is hesitant. We've given you, Jonathan has given you discussions of using a disclaimer to get property back, a Q-tip to be able to unwind the use of exemption. We've talked about how clients will benefit if the planning is done well, if you give them access and they get asset protection, why they should want to do it. But if they don't, be careful. And what are some of the other precautionary steps that you may want to take? You may want to have a balance sheet prepared for any client making transfers to show that the wealth that they're transferring is not excessive relative to the wealth they're retaining, that they can afford to make the transfer. You may want to have a solvency affidavit prepared. Some states require this for a self-settled trust. Some do not. It's not required for other types of transfers, but it's a simple document. It's a couple of pages. Why not have a solvency affidavit prepared for any multi-million-dollar transfer? I think it helps protect the client, because if somebody argues it was a fraudulent conveyance, they signed an affidavit saying that they didn't know of any other claims or issues that could have reduced the estate as illustrated on the balance sheet that you also want. I think it also helps protect you as a practitioner, because if a client signed a solvency affidavit and something comes up later, well, gee, they signed a solvency affidavit saying they had no idea of any claims. So take these kind of steps. Ideally, have the wealth advisor or accountant create some, Bob mentioned Monte Carlo simulations, forecast, modeling, show what their assets look like, show that they don't need full access to the assets in the trust, even if it's a slat or adapt that they can be a beneficiary of. Ideally, they should not have to access it under reasonable assumptions for some period of time. As I said earlier, offer the client options so that you've protected yourself, and apprise the client of that every plan has risks. You should have a standard paragraph thrown into every memo to every client, a standard paragraph in your engagement letter. Everything that we're talking about has risks. Now, Jonathan is often bold and suggests that things are assured or likely to work out, and maybe they will be, but everything has risk. We can't, and the reality is, for much of the planning we're talking, Jonathan's smiling, we can't quantify the risk. We can't. I remember when I did my MBA at my business degree, they had a fictional measure for utility or pleasure so that we could quantify things called utils. We can't measure some fictional percentage likelihood of any tax plan working out. So now we have, for the time that we have left, we're going to run through some of the planning techniques that are being commonly used at the end of 2020. And we'll get to the preferred partnership interest at the end, Jonathan. So let's take just some quick comments on slats. And I'm sure everyone's familiar with spousal lifetime access trust. Now, one of the key problems at the end of 2020 is one of the common ways and great ways to differentiate two spouses slats so they are non-reciprocal and can't be uncrossed by creditors of the IRS is by time. So how do you do this if we only have 6 weeks left before the end of 2020? Well, you can't really much differentiate them by time, and you really can't even wait for one spouse to sign it after the other very long, because you're going to have to fund the trust and there may not be a lot of time. Now, if you control the assets going in, and it's going to be, let's say, private equity, so you can have the assignments ready and have one spouse sign today and one sign, in 3 weeks, you put some time between it, but it's really not a lot. It's critical, more so now than ever, that you differentiate the trusts. I like to use different jurisdictions, different trustees. I like to have different powers of appointment, different distribution rights, and so on. And that's something, by the way, apropos to earlier comments about document generation software, those document generation software is a great tool to clearly differentiate what goes into each trust. So you need to differentiate them. You need to deal with the issue. Now, what has the election done to change that? Well, one thing that I've offered clients, but I've had zero takers, is the following. I've said to clients, listen, the blue wave didn't happen. We still have the uncertainty in the Georgia runoff elections we've talked about, but clearly, and we can't quantify it, we can't assess the risk of the Democrats winning, and I don't mean that in a political way, from a tax perspective only. But if there is less risk, which I think is a fair statement, than there was before the election, right, because the blue wave didn't happen, will we have changes, massive changes next year? So I've suggested to clients that have slats in process, weigh the risk, because we can't quantify it. There's going to be less risk if you put one spouse's slat in place now and wait till the end of January or February, or even March, to do the other spouse's slat. So there is clearly a lower risk of a reciprocal trust challenge, but how do you offset that or weigh that against the risk that the Democrats may take those 2 seats? Don't know. I've offered it to a number of clients where we have non-reciprocal slats in process, no takers. Everybody wants to get the planning done because they're uncertain what may happen with the election. Access is critical for clients. It's not just making a client a beneficiary. You can have loan provisions. I can give Bob in a non-fiduciary capacity the power to tell Peak Trust in Alaska, who's my trustee, Give Marty a loan of 200 grand. I don't care if I die owing money to the trust. Most of us tend to look at loan provisions from an income tax perspective that it characterizes the trust as a grantor trust, but look at it as an access point. Including charitable beneficiaries can help. Purchasing a vacation home can help. Income tax reimbursement. Point is, in addition to naming my spouse as a beneficiary of my SLAT, I can incorporate all these other provisions to provide access. And there's some sample SLAT provisions and a detailed checklist if you want that goes through a lot of the ways to differentiate trusts. We still need to assess on slide 81 whether we're going to do one trust or two. If a client is on this example has a $16 million estate, and they are comfortable and the financial models show they can give an $8 million gift, perhaps one spouse would each spouse would give $4 million to a separate SLAT. They'd probably be better off having one spouse give $8 million and do one SLAT, not two. So it doesn't even have to really be a SLAT. You don't have to differentiate it, which is also a positive, but you used $8 million exemption. So as Jonathan said earlier, if the exemption drops to, say, worst case scenario, 3.5 million, the spouse that was not creating a trust this year still has 3.5 million of exemption. If they both created slats for 4 million, none of them have, neither of them has any exemption left.
Yeah, now, Marty, let me interject here that I didn't finish my thought. Remember, I gave an example of your client only says I'll use 8 million of my $11.5 million exemption because I think it'll never go down below 3.5 million. Well, the Treasury has indicated that if the exemption is reduced, either in 2026 when it's cut in half or because of legislation, unless that legislation states otherwise, when you make a later gift or when you die, the gifts you've already will be made will be applied first against the remaining exemption. So you've given away 8, you think you have 3.5, and indeed maybe you have 3.5 when you die, but the $8 million gifts will be applied against the $3.5 million exemption, and so you will not get any. The bottom line is if your client wants to use exemption, they can't preserve any. They're going to have to do it whole hog or none. And that's why Marty said if you've got a married couple, maybe you have one spouse make the gifts, use his or her exemption, all of it or part of it, but preserve the balance. So even if it is reduced in the future, at least the other spouse who didn't make the gift would go ahead and at least have some exemption available.
So Jonathan, one of the things that concerns clients is I'm uncomfortable making these large gifts. My estate's worth $10, $20 million. I'm willing to give away 5 million, or if it's worth 25 million, maybe I'll give away 11 million, but I really need to preserve access to that. What about using a domestic asset protection trust? Shouldn't that be an option that people are talking about? And now we have 19 states. The number has grown from Alaska in 1997 as the first to 19 jurisdictions now permit DAPs. But it seems that as the number of jurisdictions permitting self-settled trusts has grown, the concerns of the naysayers has also grown. Thoughts on using DAPs? Should they be in the planner's toolkit?
I certainly think they should, Marty. And as you know, we'll get to it in a moment. I think there's a better way to do kind of a DAP, but certainly you can. And in fact, if you take a look at a number of cases and revenue rulings, 2004-64 at the bottom of this, revenue ruling 76-103, and private letter ruling 2009-44002, all state, if you create your trust in a DAP jurisdiction and you haven't tried to hinder, delay, or defraud a creditor, you will get protection under that state law. And because your creditors can't attach those assets under the law of the state that governs the trust, you are able to complete the gift and it will be excluded from your estate unless you have some other interest or power over it.
And let me interject what I had on a prior slide of some of the due diligence I try to get every client to do, even if it's just a SLAT, but for sure for ADAPT, get a signed balance sheet. Ideally get the accountant or wealth advisor to prepare a balance sheet so it's even more accurate than when a client does. Get financial forecasts and models done. Get lien and judgment searches, get a solvency affidavit, even if state law doesn't require it. I'm not saying any of this is a standard of practice. I'm just saying it's a nice way to help protect the client and protect yourself as a practitioner. What we do for clients making large gifts in general, but especially for DAPs, we have an independent forensic firm we have the client hire who does an analysis. They do credit searches, criminal record searches, lien and judgment searches, and so on and so forth. So we get an independent report on top of all the other stuff to help corroborate that it doesn't appear to be a fraudulent conveyance. Now, Jonathan, you kind of spilled the beans and suggested that there may be some other options. So one of the options that you may use is what's called a hybrid DAPT on slide 90. So again, I don't want a client to make transfers to use exemption and then be unhappy later they can't get access. We all remember all the buyer's remorse in 2012 planning. A lot of the planning in 2012 just simply didn't provide any means of access. Practitioners set up, and I'm not blaming the practitioners, the clients asked for it probably, and they did it like, Christmas time when there was no time to do much more, but they set up trust for kids or grandkids as opposed to trust that the client had access to. So if you want to do a DAP where the client can be a beneficiary, but you are concerned about the risk because the client lives in a jurisdiction like Florida or New York or California that seems to have a policy against self-settled trust, maybe you use a hybrid DAP. So I'm going to give Bob the power to add back beneficiaries of the trust to send it to my grandparents. And that way I'm not a beneficiary today. And let's say I put $5 million into this DAP. If I later need money, Bob the trustee may divide the trust, put $4 million in one trust, $1 million in a separate trust, and then Bob may exercise that authority and may add me back as a beneficiary of the $1 million trust. So the $4 million other trust remains intact and I'm not a beneficiary of it. So you divide the trust first. Now I'm added back as a beneficiary and I can get a distribution should I need it. So that's the concept of a hybrid DAPT and certainly should be put in. And again, be very careful as we get towards the end of 2020. Clients are going to come in, rush in, and be frantic about doing planning to safeguard the exemption. You don't want a client to make transfers of significant portions of their wealth and then later be unhappy with you because, gee, now I can't access it. So the hybrid DAPT is certainly a way to do it. The disclaimer approach that Jonathan mentioned earlier is another way to do it. And I like the disclaimer approach, whether or not the client's doing it. If you throw that into a trust and the client has regrets for doing the planning, they can undo it. So listen, client, you're unhappy you did the planning. You had another 9 months to undo it. Why didn't you talk to somebody else and undo it? Safer for the practitioner. Now, Jonathan, why didn't you talk?
Marty, let's go back one slide on the hybrid DAP, and you'll see a case called Ionati. This is a case decided in New York where a grantor who created a trust, and he was not a beneficiary of the trust, but he had a trust protector who was acting under a fiduciary duty who could add him in as a beneficiary. He applied for New York State governmental benefits, which would have been denied had it been a self-settled trust, and the court held that it was essentially self-settled because he could be added back in. Now, if you're going to use this hybrid strategy, do what Marty has done, put in an independent person like Bob Keebler, not in a fiduciary capacity, not as a trust protector with a fiduciary capacity to add you back in. But the Ionati case doesn't tell us, well, if you don't have a fiduciary, you're okay. I could see a court having the power to determine it's still a self-settled trust because you could be added back in to say it is still self-settled, subject to claims of creditors and denying of government benefits, for example, if the person involved wants to get something like Medicare.
So, Jonathan, one of the other approaches is a technique called a SPAT, a special power of appointment trust. So let's say the client is concerned about access and you want to help give clients options. And that's, again, something I know I've said, but I want to emphasize. If a client is comfortable doing non-reciprocal slats, they still have mortality risk if the spouse dies prematurely of the trust that they created. So a SPAT or a hybrid DAP mechanism grafted onto the slat. So one trust could be a slat, one could be a hybrid DAPT. You could have a hybrid DAPT and a SPAT. How does a SPAT work, Jonathan, and how can I use that to give the client access to the money in the trust?
Well, as I just indicated, you may run into trouble if you have a self-settled trust. Now, this is very, very important to listen to, and I'm going to give you a citation. All the problems with creditor claims, and therefore all the problems with estate tax inclusion, only apply to self-settled trust. And self-settled trusts are one in which the settlor, the grantor, has retained the right to things or can be given benefits in the discretion of a trustee. take a look at section 505 of the Uniform Trust Code and take a look at the commentary, and it will tell you that this rule about allowing creditors of the settlor access to the trust property only applies where the trustee can give the assets to the grantor. So Mitch Gans, my dear friend from Long Island who teaches at Hofstra and NYU in the Masters in Tax program, Abby O'Connor of Anchorage, Alaska, and I wrote an article about this thing we call the Special Power of Appointment Trust in the February 2019 issue of Estate Planning magazine. It is worth reading, because this says if you create a trust and you provide that you cannot be a beneficiary of the trust, even by a decanting, you can't be added as a beneficiary of the trust. That's not going to be a self-settled trust. Yet you will give someone in a non-fiduciary capacity who is not a beneficiary, and that a special lifetime power of appointment. That kind of special lifetime power of appointment, where it is not coupled with a beneficial interest and not held in a fiduciary capacity, is called a, I hope I'm not offending many people on this call, Marty, a naked power of appointment. And so I create a trust for my wife and kids. I expressly provide I can't receive any benefit from this trust in the discretion of the trustee, even through a decanting or otherwise. But I name Marty and Bob Keebler and Mitch Gans with the right to exercise a special power of appointment outright in favor of any descendant of my grandmother. That means that I am in the class of potential appointees, and I could go to Marty and say, Marty, would you please exercise this power to give me some of the property? I need it for a new yacht or for a hard operation or whatever. If Marty says no, I'll go to Bob. If I go to Bob and he says no, then I'll go to Mitchell. And by the way, if I've gone to all three and they turn me down, it's probably not a good idea. Now, what about the fact that Marty is angry at me for some reason because I caught a bigger fish than he did? And he said, I know what I'm going to do, Jonathan. I'm going to screw you thoroughly. I'm going to give it all to your brother, Doug. Well, can I stop that? Well, what I'm going to provide is that Marty, Bob, or Mitchell may only exercise that special lifetime naked power of appointment with the consent of my lawyer. And you know what's my guess? If Marty goes to my lawyer and says, I'm really angry at Jonathan, I want to exercise this in favor of his brother Doug because he caught a bigger fish than me again, which, by the way, I always do, then I think my lawyer will say, no, Marty, you can't. So this, I think, is, remember, I'm the starter of asset domestic trusts in Alaska in 1997, the first statute in the United States, and I'm a real fan of them. But I think this is one step better. So take a look at that article in the February 2019 issue of Estate Planning magazine and consider adding a SPAT to your arsenal of things you can do for the client. And as Marty said, one of the things you can do, I mean, here's what happens. Marty creates a trust for Patty. Patty creates a trust for Marty, but we provide that Marty has a power of appointment. So if he predeceases Patty, the trust she's created for him, he will have a power of appointment and he can appoint it back in trust for Patty. Well, maybe his Patty trust doesn't even give him that right. Maybe all she says was at any time when the trust continues after Marty dies, it continues for the children. But again, some third party has a power to appoint it back to her. So that's even a stronger kind of slat where you're expecting the spouse dying first to appoint the property back in trust for the grantor spouse. The SPAT, I am telling you, and Bob, I want you to write this down because you've never heard this before. The SPAT is the cat's meow. So keep that in mind, friends. Marty, back to you.
One of the things that you should do is I've seen a number of practitioners that I've talked to that are really using slats as sort of their default plan. Think more broadly. So one spouse can do a slat, the other can do a hybrid DAT. You can do two spats. You can do a hybrid DAT and a spat. You can do any mix and match. Make sure you're giving enough access. And by the way, if you have a slat and a spat or a hybrid DAT and a spat, those are different mechanisms. Those differences alone will help differentiate a trust for reciprocal trust doctrine purposes. And if you're struggling to get work done in two, let's say, non-reciprocal slats done before the end of the year, make one a hybrid DAT, the other a slat. Make one a spat, one a slat. You're creating yet another great difference between the trusts to help break the reciprocal trust doctrine. Now, there's a sample SPAT provision. And by the way, the provisions are courtesy of Interactive Legal and they let me steal all their language and give it to you. And throughout the handout, we have a lot of sample language that I've pulled with Interactive Legal's permission. So let me talk about GRATs for a minute, and we're not going to spend too much time because we're running out of time, and we have Vanessa Kanega is going to come back with some Q&As that people have asked that we're going to try to get to. So let me just do GRATs quickly, and then I'll let Jonathan talk about defective partnership freezes. GRATs everyone's familiar with. What's different in 2020? Well, first of all, interest rates are historic lows, so the 75-20 hurdle rate is incredibly low. It makes GRATs very valuable and very effective to use. Now, the traditional way the GRATs have been applied is short-term 2-year rolling GRATs. More traditionally, they've been done with, let's say, in a granular form. So if I'm going to do marketable security GRATs, I may put different asset classes in each GRAT. I may have international microcap equities in one. I may have Dow, large cap domestic stocks in another, et cetera. And if I can get really granular, I'd have different stocks in each GRAT, because the way a GRAT works is heads you win, tails you don't lose, and it's only the winners where you're slicing off the upside volatility. So that's the traditional application. 2 comments about 2020 late year GRAT planning. First, if we believe there's a risk that the Democrats get the 2 seats in Georgia and push through all the tax legislation Bob talked about earlier in our presentation, what we want to do is be cognizant of the fact that GRATs may be virtually eliminated. The Democratic proposals have included making a 10-year minimum term and even having, I think, a 25% minimum gift. No one's going to really do GRATs. I can't see, I mean, I don't want to say never because there's always exceptions, but I just can't see GRATs being very viable. So that means the traditional application of GRATs of short-term 2-year rolling or cascading GRATs with very granular funding to slice off the upside volatility won't work after this year, because if they make a retroactive tax change, GRATs are gone. What might that mean? That might mean that what you want to do with GRATs is lock in the low interest rate and the ability to do GRATs, because we may not be able to roll them next year. So on slide 100, maybe we do a 4, 6, 8, and 10-year GRAT, a ladder of GRATs, as opposed to short-term rolling GRATs, 2-year GRATs. When I get my annuity, I regrat. Now, if you do a 6, 8, and 10-year GRAT, for example, you have to deal with something that we've traditionally not dealt with in GRATs, and that's mortality risk. Hug your insurance agent. At least get the client to look at insurance to address the mortality risk of the client drawing during the GRAT term. It's not that GRATs didn't always embody mortality risk. They did. A 2-year GRAT has a mortality risk, but even for a client that's age 80, you may be willing, if they're in reasonable health, to take a risk for 2 years. You may not be reasonable or comfortable, or the client may not be taking a risk for 6, 8, or 10 or longer number of years. So look at insurance. Another thing that changes in GRATs is the concept of immunization. So if I bought Zoom stock in a GRAT and it popped really large, I would swap out the Zoom stock for cash and let the cash ride out the remaining term of the GRAT. Well, that's fine when a GRAT is no more than 2 years. So if a year into the GRAT, worst case scenario, I pull out this high-flying stock, locked in or immunize the GRAT, and ride it out with cash or T-bills, which basically are paying nothing now. But the problem with the longer term GRAT is somebody's not going to sit on cash for 6 years of a remaining GRAT term. You're going to have to either get a diversified portfolio or use some of the financial engineering strategies that Bob talked about earlier to hedge the downside, so you keep that gain locked in. Now, another thing, and I'm going to do it quickly and then flip it back to Jonathan, is using a 99-year GRAT. Interest rates are at historic lows. If you die during the GRAT term, people mistakenly assume the whole GRAT is back in the estate. It's not correct. What's back in the estate is the annuity payment divided by the 75-20 rate at the date of death. So if interest rates triple by the time a client dies, we don't think that the client's going to live 99 years, but they may live 10 or 15 years. Interest rates may be dramatically higher. We just by a pure interest rate play may have shifted a lot of value out. So a thought for sort of a Hail Mary at the end of 2020, if a client is getting anxious about that election in Georgia, let's say the polls show the Democrats well ahead on both seats, throw a 99-year GRAT pass and see if somebody can catch it in the end zone. So keep that in mind in your toolkit for late planning. Jonathan, can you do a quickie on split purchase annuity trusts?
Yeah, the split purchase annuity trust is based upon the same rule under section 2702 that we have for GRATs. And basically, here's what happens. I take a pool of my assets and I put it into a single member LLC. That's a disregarded entity. Then I go to the LLC and I say, I want to buy an annuity for my life. And I pay by some other asset to that LLC. It'll be a non-taxable transaction because it's disregarded. And I buy an annuity for life. And I can buy an annuity of such size that I can buy back, say, 95% of the value of the assets. So if the LLC holds 10 million of assets, I'm going to pay 9.5 million for an annuity for life. A GST exempt grantor trust with respect to me comes back in and buys the remainder that will exist after my annuity ends. So there's no gift at all because each party has paid 100% of value. There is no income tax because we have disregarded entities. When I die, nothing will be includable in my estate because I have purchased the annuity and the GST exempt trust has purchased it. The advantages here are the client knows that the client can have an annuity payment for life without concern about estate tax inclusion. It's going to end. And you can even use this for a client with a diminished life expectancy as long as death is not imminent. If there's more than a 50% chance of survival for a year, you can use standard mortality tables. And it means that now when I die, the GST exempt trust will succeed to the remaining assets. And if we've had reasonable performance, and I hope we would since the section 7520 rate has been so low, they will succeed. The assets will go into the GST exempt trust and they will be exempt from generation skipping, which normally you cannot do with a GRAT. It is very much worthwhile looking at. If you want more information about this, take a look at portfolio. The Bloomberg portfolio used to be the BNA tax management portfolio. 836 second by my former partner, Georgiana Slade, my darling friend, Diana Zadel, and me.
So another technique we'll do quickly, and then I'm going to flip it back to Jonathan for our last technique, and then we'll start taking questions. I'm seeing a lot of note sale transactions being done. People are trying to lock in the discounts. Bob and Jonathan and I talked about how discounts may be reduced, even if the Democrats don't win those 2 seats in Georgia, just by legislative action. I'm seeing clients use note sale transactions to lock in current values of depressed businesses. Some businesses values have stayed the course. Some have even increased. Because they're benefiting from COVID. Many businesses are still at depressed values, even though the stock market has gone to record heights. We still have clients with low valued assets. So it's a great opportune time to lock in a low value, to lock in discounts, to lock in a note with the current low interest rate. Clients can thereby shift much larger values than the exemption amounts to trust. There's a lot of interesting applications and techniques of note sales. One of the things, just for consideration and thought, is sort of what I call on slide 108 an off-label application. The client might be able to make a gift, but they're going to do a note sale because they want to lock in the current value, they want to lock in discounts, they want to lock in the low interest rate, but they're not willing to let go. So, one approach is that you sell it to lock those benefits in, but the client can at least get the note payments back so they haven't given up everything. Another spin on that, which is what I call off-label, is to use a note sale if the client is still hemming and hawing about what they want to do in terms of completing a transfer this year. They could do a note sale even for the 11.58 million, just have seed capital in there, and let's say do a note sale for 10 million, and then forgive the notes on December 31st. So it gives them some look back to finalize a transaction if they want. One of the other things on 109, and there's a lot of different techniques and issues on note sale transactions, but with the Powell case, one of the concerns is if you do a sale or a gift with a Wandry clause, that I'm selling $100 million of stock. Well, if the stock is valued at 200 million, I have half the stock in my name. So one of the approaches that I use to address that is what I call a double Wandry. I'm going to sell the stock for 100 million. I'm going to sign a secondary stock purchase agreement, sale and purchase agreement, that I'm going to sell any shares that were left in my name as a result of the application of the Wandry for gift tax value is finally determined. So under current law, I've moved the entirety of the asset out of my name. Jonathan, just to wrap up our whole discussion, why don't you take a minute and talk about the deferred interest gift?
Yeah, this is something that really should be considered for a client who wants to use the exemption but wants to be able to benefit with the property and not have to worry about making a mistake. And here's the way it works. Section 2701, we know, says if you and a younger member of your family get together where you take a preferred interest, like preferred stock in a corporation or the equivalent in a partnership, and the descendants in your family, directly or through a trust, wind up getting the common or growth interest in the entity, then you will have made a gift equal to the amount you paid for the value of your preferred interest, unless it's qualified preferred, and you'll make sure it is not qualified preferred. This means that I can go ahead and take, say, $9 million, put it into a partnership, retaining a preferred return, which, by the way, could even include not just a fixed rate, but some part of additional growth. And my kid or a trust for my kids would go ahead and buy the common interest in it. That will mean I have made a gift to my kids of $9 million. And that means, even though I still own it, now I own the preferred, I could sell it, I can get dividends on it, but I've now made a gift, even though I haven't transferred the property. So when I die, that preferred stock, which I can be sure is worth $9 million because there'll be a put right to provide that at any time it can be put back to the partnership at $9 million, I've now made a $9 million gift. But under the regs under section 25.2701-6, it says that the amount of the preferred stock will be excluded from your estate. So you make the gift now, you keep the property, but it will not be taxed when you die. So you can retain basically the income in that without worrying about any adverse effect whatsoever. This is really something for your clients, and it doesn't have to be done with a closely held business. It could be done just with a portfolio. So if you have a client with a portfolio and she'd be willing to use her exemption, you can consider having that client put $11,580,000 into the partnership, having GST exempt trusts go ahead and buy the remainder, because, by the way, 2701 does not apply for generation skipping transfer tax purposes. And now you will have made a gift of $11,580,000. It'll be includable in your estate, but it will not be taxed again. So it's a way to use your exemption and yet keep the practical full benefit of the property until you die.
So just to wrap up, we've talked about how to unwind planning, so we're not going to do it. So what we've tried to do in this program is give you, through Bob's insights, some planning ideas to deal with the income tax uncertainty of what the election where we're standing right now means, and some steps that you may want to take before year end. Jonathan and I have talked about estate planning techniques that you may want to use and why in the waning days of 2020. I've tried to highlight some of the foot faults that you want to be careful of to keep yourself and your clients safe. And we've tried to give you a lot of different techniques and how to apply them at the end of the year, and also to highlight some of the things that are unique or different about the compressed planning time period remaining in 2020. Bob, do you want to make any last minute summaries or thoughts?
I just wanted to regroup a little bit on the grip Jonathan talked about, that last technique. What everyone's missing is the basis adjustment. If we keep basis adjustment, that preferred is going to be included in your estate when you die, and there'll be a basis adjustment for super low basis property, a freeze partnership or the grip might have that other advantage. We just built a big economic model to demonstrate this, and we were kind of surprised, but we compared the grip technique to the slat with low basis property, and the grip hands down just destroyed the slat. So there's an opportunity there for you to think about.
Jonathan, any final words, thoughts?
No, Marty, we have certainly run over as you forecast we would, and I guess it's time for Vanessa.
Vanessa, are you there?
I'm here. Let me see if I can turn my camera on.
There you are.
All right. Hi, everyone. And thank you all. Thank you to the three of our panelists for taking these questions. So I'll just dive right in. Most of the questions we received were sort of generally related to gifting, and then we have a couple on some specific techniques that we'll get to. So this first question is a very simple question that I think does not have a simple answer, but it's kind of the $12 million question, if you will. This person just simply asked, should wealthy clients transfer $11.6 million before December 31st of this year?
11.58. Yes.
Yeah.
But they should do it carefully, meaning it should be done into a trust that provides access that's appropriate for the client's overall wealth and needs. So there's not enough facts there, but if the client's worth $100 million, for sure use it, and they probably want to leverage using some of the other techniques we've talked about, even more wealth. If the client's worth $20 million and they're going to give away 11.58, unless they have a very low lifestyle expense level, they're going to have to make sure they maintain access to it. And I would suggest, even if they don't need it, let's say the client's worth 20 million and is spending at a low enough level that they don't need access to the 11.58, I would still preserve access, because if you did a slat, for example, or some other technique where they have access, if they don't need it, it just stays in the trust and can go to the heirs, but at least they've preserved access.
Well, and you talk about preserving access, Marty, and one of the other questions that we received relates to that. It says, any planning ideas for a single person with no children but who has siblings, nieces, and nephews? I think what they're getting at there is, one of the common techniques is the slat, which of course gives the spouse access to the property gifted. What do you do for a person who doesn't have a spouse?
Jonathan, tell them about the Lehman
what are your
Brothers.
recommendations?
Well, the first reciprocal trust tax case involved two Lehman Brothers of the famous Lehman Brothers firm, where the older brother created an identical trust with identical assets with identical trustees for the younger brother, and the younger brother did the same. When the older brother died, the courts, including up to the Second Circuit, agreed that basically you'd unswitch those. So you can do it with a sibling. But as I said, if you're single, you have other options. You could do adapt. You could also do this preferred partnership, which will be defective under Section 2701. If I had a single client, I would certainly say, let's consider that. By the way, you can manage the partnership. You can decide, stocks and bonds. You can receive a percentage dividend each year, or the equivalent of a dividend in a partnership, and you can participate in some additional growth, but it will be preferred. And that, to me, is probably what I would roll out. But as Marty said, there's a lot of choices. Let the client know there are choices on what you want to do.
This person asks what I thought was an interesting question that's not going to apply, as far as I know, is probably only going to apply to people in this state, if I'm remembering correctly, but it's an interesting question. They're in Connecticut, and they say, what do you recommend for Connecticut clients who face a gift tax? Connecticut has a gift tax with an exemption of only $5.1 million, which phases out by 2023. And by that, I think they mean that it then matches the federal exemption beginning in 2023. So you've got clients who want to use their full federal exemption, but they're faced with this potential state gift tax.
Well, this is a problem, but let me tell you what you can do, and it's a big step. The client could buy gold in Alaska or silver in Nevada, and I mean really buy bars that you can prove you own, and then give those away. The law is quite clear that a state may not impose a wealth transfer tax on tangible personal property actually situated in another state. So you could have the client buy $11 million worth of gold in Alaska or silver in Nevada, and there is some risk, and I would have it bought, have it given away under the protection, have the recipient keep it for a while, and then maybe sell it or do some sort of hedging. That, I think, is something that can be done. Your client might say, no, I don't want to do that. Well, the client doesn't want to do it. Maybe they want to pay gift tax. They could buy other tangibles as well. They could buy a painting, for example, and keep it out of the state. But to me, if you're buying something like gold or silver or something that's a real tangible, you can definitely tell that it's not in the state, because you're going to have gold bars with numbers on them, or you're going to have silver bars with numbers on them, and you can show this was in Nevada at the time I gave it away. So that's something that I think they can do.
What if you gave a gift up to the exemption and did a note sale for the excess? And then later when the exemption gets higher, well, I guess at least you've frozen value. You may have locked in some discount. You've done something even though you haven't used all the exemption.
Well, that's definitely an interesting approach, Jonathan. It's not at all what I expected you to say, but it's an interesting idea. We had a couple of questions relating to the clawback. So you all discussed that we have regulations saying that if you use your full exemption now and then the exemption drops by the time the person dies, there are regulations saying that that additional exemption that was used on the gift is not going to be clawed back at the time of death. For estate tax purposes. So there's a couple of questions relating to this. The first question is just basically how permanent is permanent? So in other words, could the IRS, could Treasury reverse those regulations and reverse the sort of rule that they're not going to claw this back? And then the second kind of related question that's related to the anti-clawback regulations is that there was a preamble in those regulations about anti-abuse of the clawback regulations, and basically protecting against these so-called artificial gifts. The idea being that a person would make a gift using their full exemption that would then be included back in their estate, so that they get the advantage of the additional exemption amount, and that's potentially an abusive transaction. And so the first question is, I guess, how permanent are the clawback regulations, saying there's not going to be any clawback? And then should we be worried about the Treasury enacting anti-abuse regulations as well?
Well, Austin Bramwell has certainly been concerned about anti-abuse regulations, and you may remember that he was actually in the Treasury under the Donald Bush regime for a while. Austin thinks it's unlikely. I think it's unlikely because Section 7805 subdivision B basically says that the Treasury cannot issue retroactive regulations as a general rule unless it is to curb an abuse. The fact that they just did this seems to me to say it's not an abuse. If they've created some sort of abuse in the regulations, change it. I think the chances of that being changed retroactively is extremely small. Understanding that the Supreme Court can say whatever it wants to say. So, you cannot be absolutely, morally certain. I might be willing to risk the life of my cat, not one of my children, but I might be willing to risk the life of my cat, that if they change these clawback regulations, it will not be done retroactively.
Great. This person asked, how do you deal with the loss of step up in basis when making gifts? They have clients whose CPAs have advised not to make gifts because of the loss of the step up in basis. How do you deal with that, particularly now, given the uncertainty that you talked about as to whether we'll have step up for much longer?
Borrow.
Well,
you can borrow money and give away the money you borrowed, and then you don't have a basis issue. That's been a commonly used technique for people with highly appreciated assets.
but let's focus on the math. If you live in Florida, the most the step up in basis is going to save you is 23.8%. And you're going to be able to save 40% on the estate tax side of things. So there's an arbitrage there of 16.2%. There's no way you're going to lose that, because you see, we're in this use it or lose it situation with the exemption, if you truly believe that. So those CPAs are simply wrong. Now, if you live in California, that gap narrows. 40% federal tax, about 23.8 plus 13.3, that comes to 37.1. Then maybe it's a little bit more persuasive. Now, if you have real estate that's going to get a very valuable step up in basis because of depreciation, because the depreciation recapture is worth more than 23.8, again, the gap narrows. But the thing is, the income tax can be controlled. The estate tax can't. I die, 9 months later, we got an estate tax. The income tax, my family can do 1031 exchanges. They can hold things. So realistically, I think you have to ask those CPAs to model this out and prove their theory. And they'll come back to you probably with a little bit different perspective once they really do the numbers.
I think that's really good advice. Let's see. There's a question here about CRUTs and CLATs. Are they at risk next year? And I think this person is just asking, is there any concern about any changes in those laws that permit the split interest charitable gift?
I haven't heard of any at all. The charitable remainder trust, as we discussed, may be coming much back more in vogue. As you know, I've discussed this in the context of qualified plans and IRAs using a charitable remainder trust, in particular, an income only with makeup charitable remainder uni trust. CLATs, in fact, there's going to be a presentation later today on LISI, Steve Leinberg's program, by Jerry Hess and I think Alan Gassman about using charitable lead trusts. But generally, you cannot have your cake and eat it too, because you only get an income tax deduction if you make it a grantor trust, which means you're trading a current deduction for later income. So charitable lead trusts can be good. They are used primarily for purposes of reducing estate or gift tax, and not for purposes of reducing income tax or to avoid GST tax.
It would seem that if, and it's a big if because we have obviously no idea what's going to happen politically, but if the Democrats got those 2 seats, which is an if, and if they pushed through tax legislation along the lines of the harshest proposals, let's say like a Bernie Sanders for the other 99.8% bill, it would seem that charitable trust and life insurance planning are going to be 2 of the hot items that remain for planners. So, I would think that charitable trusts and life insurance, if all those things go through, will be hot planning tools, because many of the other tools that we have will be either eliminated or so restricted that they won't have the zip that they do now.
Right. So in other words, there may be more of a focus on those trusts rather than being at risk.
The big question, Vanessa, is what's going to happen, and my Ouija board burnt out. I can't predict too well.
No Ouija boards, no magic 8 balls. Understood. Well, this last question on the sort of general gifting issues, I think relates to something that you've talked about, Jonathan, which is the real advantage of using the current exemption levels to use the full exemption amount, right? Not some lesser amount. And this person asks, if client makes a $10 million gift, will the $5 million not be clawed back? Or is Jonathan certain that there is no benefit if you're not using all of the exemption? Can you speak to that? I think the issue is not so much the clawback, but rather that, you're not really getting the advantage if you don't use the full thing. Is that right?
Yeah, I mean, again, you can give away $11.5 million today. It'll stay out of your estate. How much benefit or how much control you retain is some of the things we've talked about. But you get it, and then it doesn't matter to you what the exemption is when you die. You've used $11.5 million. That's a huge amount to get out of your estate, and it will presumably grow for the balance of your lifetime. So that's good. If you don't make the gift and the legislation stays in effect, so in 2026 it's cut in half, then you're only going to have that much exemption. If it's cut down by prior legislation to say $3.5 million or even $1 million, that's all you're going to have unless you've used it. But again, I want to emphasize that the Treasury has said 2 things. Number one, if you use the exemption today, even if it's reduced in the future, we won't claw back the benefit. So if you give away $11.5 million today, when you die, you're not going to have to start paying estate tax on that $11.5 million. It'll come back in as an adjusted taxable gift, but it's not going to push you back up so you're paying tax on that $11.5 million. Very, very important to understand. But the other thing is you can't preserve only part. If you give away $3 million, you're not going to preserve whatever is left below the 3 million. So if it goes down to 5 million, you've used 3, you'd have 2. But I think that if you really want to do aggressive planning, you've got to use your full exemption. And that is limited to those of us who, unlike Bob and Marty and you, Vanessa, who don't have 11.5 million per spouse to give away. You've got to think about something like, maybe, giving away a gift by promise.
But don't let that detract you from doing planning for people. If somebody has a $10 million estate and is not comfortable doing a gift for promise, can't get it done by year end in Pennsylvania, and they use $5 million of exemption, they can have effectively used enough exemption to get great asset protection planning. And if the grantor trust rules stay in place and we don't have that trust pulled back into their estate if they change grantor trust rules, then by simply paying the income tax on what you've given away, you're going to burn down the rest of your assets. Lifestyle expenses and income tax will burn down the rest of what you have. And the $5 million you've put in a trust over the next 20, 30 years of your life will compound, and you've got a great plan. So I agree with Jonathan, but don't use that as an excuse not to plan.
Right. So in other words, the advantages of gift planning that we've always talked about are still there, and let's not lose sight of those.
And it's also asset protection planning. Everybody should be doing that.
Right. Well, that's actually the next set of questions we have. We had a few questions on asset protection trust. And I think in general, people are concerned if they live in a non-asset protection trust jurisdiction. And you talked about this a little bit. They're concerned about creditors still being able to reach those assets, even if they create a trust in Delaware, Alaska, Nevada, because the client is actually domiciled in a non-APT jurisdiction. Could you talk about that? Is the hybrid asset protection trust the solution there?
I don't think so. What you want to do is to take a look at a state of German, German, 7 Court of Claims, page 643, 1985. It's such an important case that I know the citation by heart. 7 Court of Claims, page 643, 1985. Mrs. German created a trust. She was a Floridian. She created a trust governed by Maryland law. And one of the trustees was her son who lived in Maryland. When she died, she was a discretionary beneficiary of the trust. And when she died, the IRS said those assets are includable in her estate because they're subject to the claims of her creditors under Maryland law. The court went through an analysis and the IRS kind of blew it. I was tangentially involved in this case, and it did not adequately prove that under Maryland law, her creditors could attach the assets. Notice I said Maryland law, not Florida law where she lived. So if you do it in a state, and I would make it as much part of that state as you want. You want to do Delaware? Only have Delaware trustees. Only have a Delaware trust protector, or at least a trust protector in another DAP jurisdiction. Don't go whole hard. Just don't leave a few toes in the water, as happened in Ray Huber, which was a bankruptcy case decided where Mr. Huber was a Washington resident. He created a trust in Alaska, but virtually all of the contacts, all the big trustees, the trust protectors, the beneficiaries, the assets were all in the state of Washington.
But Jonathan and Huber weren't the facts pretty bad too? I mean, I think
he
had a lawsuit with his real estate partner who was in default under, I think, 3 different loans.
Right, and he got lots of distributions from the trust. You want to be as pure as Caesar's wife on this. And the time you want to do your asset protection is when you don't have creditors. That's the time to do it. And by the way, after the Alaska Trust Act in 1997 passed, I was invited to the annual meeting of the United States bankruptcy judges. And they said, Mr. Blattmacher, we want to find out about this Alaska law. And I said, look, I wasn't trying to get this law passed. And I didn't draft the law so that people could bilk their creditors. I did it so people would be more prone to do good lifetime estate planning. There were about 40 judges there, and 5 or 6 of them had a real dialogue with me, and nobody at least openly disagreed. And they said, if you could prove to us that you were doing this for legitimate estate planning purposes, we would not try to bring those assets back into the client's bankrupt estate. I think there's no guarantees in life, but it's pretty good indication that if you go to a DAP jurisdiction, you try to get everything you can in that jurisdiction and not begin to cheat on the edges like, a co-trustee in New York or Florida, or a trust protector in Florida or California. You're going to have a much better time.
You can also place assets in that jurisdiction. You can do the lien and judgment and due diligence steps that go beyond just a solvency affidavit that I talked about and that are in the slides. There's a lot of things you can do to bolster the planning. And by the way, if you want asset protection planning, isn't now the exact time you want to do it? Because if you wait till next year and there's no threat of, let's say the Republicans get both seats in Georgia, and it seems highly unlikely the Democrats are going to put a tax change through. So if your client's a physician with a $6-8 million net worth and they want to protect some assets, isn't today the day they should do it? Because right now, today, there's this incredible uncertainty of where the tax laws may go. The tax motivation for the planning for the asset protection trust, the DAP that Jonathan just gave, is dependent on the tax environment. All the more reason that every doctor client should be jumping on this now.
Right. So in other words, it creates good facts to further bolster the planning purpose. Yeah, that's
they would
that's
replay
a really
our
point.
webinar to show why we're telling everyone to plan now. That
Right.
would be Exhibit A. Jonathan's
I'm glad I
video
brushed
on the
my hair
webinar.
this morning. Yeah. Well, so Jonathan, you mentioned Alaska, and that's a very established asset protection trust jurisdiction. We had somebody ask about some of the newer APT jurisdictions like Missouri, Tennessee, Oklahoma. Is there any greater concern about?
We're one of the newest.
That's very recent.
That's where I am right
yes.
now. I am ensconced in my home in Connecticut, which is an APT jurisdiction. Right, Jonathan?
Like your asset protection trust and gift tax.
There are variations of the various states, and different people have different views. I think Alaska is as good as you can get. It also has the weakest fraudulent conveyance statute. It has the old one, and almost all states have adopted the other. But Oklahoma, for example, you're limited to $1 million. So I don't think you want to use Oklahoma unless you're happy to limit it to $1 million. But if you're an Oklahoman and you want to do a trust, say in South Dakota, which has a good statute, Delaware, which has a good statute, Nevada, Alaska, New Hampshire has a good statute, you can use that. And because you live in Oklahoma, I think there's a good chance that the courts would respect that. They wouldn't say, well, Oklahoma only said $1 million and you put in 5, so we're going to disallow 4 million. Again, the only reason you'd be turned down is there's a very strong public policy against self-settled trust. But keep in mind that even those states which beat on the table and say we hate self-settled trust, that's not true. For example, what is an IRA? An IRA is a self-settled American trust. And yet almost all states provide complete protection for it. And even those like California and Indiana, which don't provide complete protection, give some. So you can't say absolutely without question, you know, self-settled trusts are the work of the devil and you ought to stay away from them for all time. But again, if you want to go to a strong DAP state like Delaware, South Dakota, Nevada, Alaska, try to get as many contacts as you can within that state. And if you need other people, try to get those other people. I mean, maybe you have a cousin, for example, in New Hampshire, which respects self-settled trust. Or, you know, you have a brother who now lives in Delaware. As long as you can keep almost everything you want in that state. For example, let's say, well, what else could I do? Well, maybe you form a limited partnership in South Dakota. So your asset is a South Dakota asset. That's really going to help, I think, when you have a judge. Understanding bad facts make bad law. So, you know, if you're out there trying to cheat your spouse by creating a self-settled trust and the judge is really furious with you, you know, you may lose. And the bad cases which have been decided in the recent years have all involved, as Marty was saying with the Hubert case, very bad facts.
The facts in the cases that have been decided have been, generally speaking, very bad. And if you take the precautions that we talked about in this program, you're going to weed out a client in those kind of circumstances and not do a DAP for those clients. And apropos to Jonathan's client, I have a DAP in Alaska. I set it up in 1998, I think within about 6 months of Alaska passing the statute. I have an Alaskan LLC that owns our liquid assets that's owned by the DAP and other trust-friendly jurisdiction slats. So, you know, you can reinforce a lot of these things just by taking practical steps. I think one of the questions is, you know, how much of that can you get done by year end if it's already mid-November and you got to get this done in 6 weeks? So, you know, unfortunately, it would be preferable to have it all in place from the get-go. But what you might have to explain to a client is, listen, we'll get the DAP set up because that makes sense. Make sure the client understands there's incremental risk, but we can't weigh it. And we'll go back next year, even though it's not optimal, and we'll create a LLC or a partnership in Nevada where your trust is, or in South Dakota, and we'll fund it then, and so on and so forth. And maybe we'll move your assets there. Maybe we'll identify, you know, more advisors or directors that can be named in those jurisdictions. But I think one of the things from a practical perspective is we can't do all of that now and still get it done by year end in many cases. Just advise the client there's some incremental risk of that, and you got to come back next year and let us finish, you know, tidying it up.
Right. But you can still do all the solvency affidavit and the balance sheet and all of the
absolutely,
yeah, that you recommend.
Should we order luncheon and just keep going and do another 2 hours?
Well, I only have one more question, and I think it should be pretty straightforward. It relates to the disclaimer approach that Jonathan talked about. And this person asked, if you're using this disclaimer approach, would you need to seed the trust with a small gift? So in other words, before you make the gift that could be disclaimed, do you seed the trust with a smaller gift first?
Well, that's a great question. I don't know the answer to that. I don't think there's any harm in doing it that way. That way, you know, you have a trust. But certainly if I create a trust and I'm going to make a gift, I just make the gift. I think the gift is going to be total and complete, even if it's not originally seeded with anything. And the client could always, you know, disclaim 99%. Keep in mind the following. The regulations under Section 2518 are very clear. To the extent you make a qualified disclaimer, and again, you want to take a look at the Alaska statute and take a look at the state of Honig, which I gave you the site for before. It's treated as though you never made the gift to begin with. So you sign the trust, you transfer the assets to the trustee, but the trustee is permitted to, and it does make a qualified disclaimer, but it'll do it under, say, Alaska law following the statute I mentioned, 70.030B1, and do it pursuant to 2518. So there's no acceptance of that. In fact, the trustee might even say to the donor, I have not yet accepted this gift. And or to the extent that the trustee makes the disclaimer, it will go back and nothing has to be reported, not to the gift of the trust, because the regs say under 2518, it's treated as though it's not made. And the regs and 2518 says the disclaiming will not be a gift. And we know that a trustee can't make a gift in any event.
Jonathan, if I set up a trust in Alaska, if I don't put any money in it, but I have a signed trust instrument and a trustee in Alaska, do I have a valid trust, or do I need property?
I think, Marty, once you transfer assets to that trust, you have a valid trust. But not
what if I don't have assets in the trust? Is it still a valid?
Under Alaska law, I don't think so. I think, you know, they require the proverbial peppercorn.
Okay.
So in other words, particularly if you're giving the trustee the power to disclaim, you might want to put that proverbial peppercorn in the trust to make sure you have a valid trust so that the trustee has the ability to disclaim.
I'm not sure that's necessary. I don't think that's going to, because don't forget, if the person is going to disclaim everything, you have nothing left in the trust. The trust is irrelevant anyhow, right?
Right. Okay. But the instrument gives the trustee the ability to do it.
I'm not sure in the end it makes any difference. But go back to the comments that I made earlier in the program. When a client is anxious to have a disclaimer provision to unravel the planning, I think you need to discuss with the client why they're doing it. You know, if you have all these assets in a trust, you know, you're getting asset protection planning. The exemption's going down anyhow. We're going to have another election in 2 years for Congress. We're going to have another presidential election in 2024. You know, is there really a harm in getting it? What is the client really concerned about? Have you not given them enough access? Have you not really addressed what their issues or concerns are with establishing the trust? You know, if they're concerned about how assets are going to be divvied up between heirs, then, you know, maybe a lifetime limited power of appointment is a better solution. I'm just not sure unraveling a trust that's well done is the best option. So let me thank Vanessa and Interactive Legal for jumping on with all these questions. I hope those were helpful. They were certainly interesting. I want to thank both Jonathan Blottmacher and Robert Keebler for persisting for a very long webinar that I thought was very interesting. I took lots of notes myself that I thought were interesting. So if I learned something, hopefully all of you did too. We tried to keep it practical and useful at this very trying and bizarre time that we're living through. I'd like to thank Peak Trust, our other sponsor, and also Jeremy Belsky from Boys Town, which is truly an incredible charity. Keep them in mind. Thank you everyone for joining us, and good luck.